This one. Mic check, mic check. Keep going. You want me to keep it on? Keep it on?
system. So if I lose you, that's because something went wrong on my end. But otherwise, I'll be talking to you from a microphone. 1 second. Okay, hold on 1 moment. Check 1, 2. Can you hear me, operator?
Yes, I can.
Okay, could you speak to me just a little bit more so I can get a level off your conference system?
Sure, absolutely. The line is coming through clear. Friday, the weekend's coming up.
Okay, excellent.
You guys
Thank
will
you,
love it.
ma'am. Do you hear me loud and clear?
I do. There is a little bit of an echo, but I know that you're in a big room, so
Right, and we have a live mic, so that's unavoidable.
right.
Thank you very much, ma'am. Okay, I'm going to be taking this mic offline, so my room's going to sound dead to you, operator, but that's just because I'm intentionally not feeding you audio.
No, that's okay. And I did just have a quick question. I'm guessing that there's no opening script or anything that you need me to read when you start, right? Or do you
Not that I'm
need me to
aware
do
of.
an opening? Okay. All right. If you do need anything, I'll be right here.
Thank you, ma'am. I had to. This way we can go.
Lenore has joined.
To do that, and you leave yours on. on. Like at home, red light.
You don't hear anything unless you, yeah, go ahead and turn it on. Check. Do we have anybody on the line right now? Is Lenora on the
I'm on
line?
the line. I'm on the line.
Excellent. We're with you. We can hear you. Can you hear us?
Yes.
Excellent. Okay, Shiva, we're getting close to going live. You guy knows to frame up hands, right? No, just black. I was thinking of building one, but I mean, it's already, they didn't call my computer, they're using my computer. No, literally, I would do this job for free for this. I just don't want the company getting used to the idea that I've just got to fail with my computer.
Another weird thing about this is I can't figure it out. This picture, what you see is correct, but this picture is flipped. It's left to right. The output is coming out correct.
Oh, okay.
What I'm viewing,
Well, so long as the output's correct.
the recording. You're not gonna record the sign language person. Even the sign language person.
Oh, he said.
Oh, see each other?
That's okay.
But I don't know if we have enough SD.
Gio probably knows. I don't know.
Yeah,
I mean, he knows how much is on the SD card.
Yeah, check with them again because they told me only when somebody is speaking before. But check with them again. We may have to see it. We can pass. We're gonna have to start.
Yeah, we're about to start. We need to get on it. By the way, the top attack mic is.
Here, turn it on.
You probably wouldn't hear it. What's this line level or mic level? That's line. Line level? Yes. It's line level. That's he's got the same feed you got. You and him have exactly the same thing. Mm-hmm. Okay. Press had some questions, but I think they're okay. Okay. I'm ready for it whenever she is ready to go.
Okay, tell Justin.
Justin. So.
I'm going to call us to order. If we can all get seated and ready. This briefing of the U.S. Commission on Civil Rights comes to order at 9 a.m. on February 2, 2018, and takes place at the Marriott Crabtree of Raleigh-Durham, located at 4500 Marriott Drive, Raleigh, North Carolina, 27612. I'm Chair Catherine Lehman. Commissioners present at this briefing in addition to me are the Vice Chair Timmons Goodson, Commissioner Degbele, Commissioner Harriet, Commissioner Narasaki, and Commissioner Yaki. A quorum of the commissioners is present. Is the court reporter present? Thank you. Is the staff director present?
Present.
Thank you. And welcome everyone to our briefing titled An Assessment of Minority Voting Rights Access in the United States. In today's briefing, the Commission examines voter access, including federal voting rights enforcement, efforts after the 2006 reauthorization of the temporary provisions of the Voting Rights Act of 1965, and the impact of the United States Supreme Court's decision in Shelby County versus Holder on the Department of Justice enforcement strategies and priorities. Throughout the 60-year history of this commission, voting rights have been a core component of the commission's focus and work. In light of the fundamental nature of voting rights, the commission was established in 1957 in part to address issues with voting access in our country. In the years leading to the passage of the 1965 Voting Rights Act, the commission held hearings and issued reports on voting rights abuses. In our early years, the commission went to Mississippi and invited community members to testify to their experiences trying to vote. People testified to being turned away, to being tested about their detailed knowledge of constitutional meaning. Elections officials disputed these claims until the commission enforced subpoena power to receive records, ultimately laying the data groundwork to support the Voting Rights Act. In March of 1965, President Johnson called for new voting legislation embodying the recommendations of the Civil Rights Commission, and Congress passed the Voting Rights Act. In the state of South Carolina versus Katzenbach, the Supreme Court rejected a challenge to the constitutionality of the 1965 Voting Rights Act, in part relying on data published by the Commission. Since those early days, the Commission has published 20 reports focused specifically on voting rights, and our most recent report was last year. The issues in these reports have included access to voter registration without artificial barriers like literacy tests and poll taxes, the ability to vote without intimidation, larger structural barriers such as gerrymandering the way district lines were drawn to defeat candidates of color, non-English language access, and the role of federal enforcement. The Commission's focus over these decades on voting rights reflects the continuing contest that persists over voting rights and underscores the significance of voting rights as an issue and what is at stake for democracy when those rights are curtailed. The Commission rightly recognized in our first report that, quote, "the right to vote is the cornerstone of the Republic and the key to all other civil rights." As is likely typical of Black families like mine, I grew up hearing regular admonitions that we died for this right, the right to vote, and so we must use it. It is my honor to conduct this briefing today and further the availability and protection of the right to vote together with my fellow commissioners. We are fortunate to have with us a living exemplar of the success and ongoing vitality of the Voting Rights Act promises. Vice Chair Timmons Goodson, to my left, served as the first Black woman on the North Carolina Supreme Court. She was first appointed by the governor and then elected to that statewide office in 2006, a result that would have been unlikely and even impossible in a time before the Voting Rights Act of 1965. The Vice Chair's exemplary service on the court is matched by her service here at the Commission, for which I am very grateful. I look forward to working with my colleagues to draw conclusions and make recommendations after reviewing the materials submitted to the Commission and benefiting from today's briefing. Today's briefing features 23 distinguished speakers who will provide us with an array of viewpoints as well as the opportunity to hear from the public. The first panel includes policy experts and former government officials who will speak to the scope and efficacy of the Department of Justice enforcement of the Voting Rights Act. I note the Commission staff invited current officials from relevant offices in the Department of Justice, but they declined to participate in today's briefing. They have, however, produced data and documents responsive to our requests, and Commission staff look forward to reviewing these materials for inclusion in our report. The second panel includes litigators and advocates who will speak to the laws affecting voter access since the Shelby County decision. The third panel includes policy experts, academics, and practitioners who will speak to voter access generally. The fourth panel includes election administrators, advocates, and academics who will speak to recommendations for ensuring access to the ballot in the context of changes since the Shelby County decision. I thank all who have joined us today to focus on this critical topic. Your views help us to fulfill our mission to be the nation's eyes and ears on civil rights. We will, following this briefing, work on collecting the materials that you have shared with us, review those materials, and the commission staff will prepare a report that the commissioners will vote on and ultimately will produce to the public to make recommendations about civil rights policy with respect to voting rights. And now we'll pass the mic to Commissioner Harriet, who I understand would like to say a few words.
Thank you, Madam Chairman. I know my commission colleagues have said they're looking forward to today's testimony, but I'm not sure I can say the same thing. Of all the areas of civil rights law and policy, voting rights policy may be my least favorite. Why? Because as important as voting rights are, lurking beneath the most aggressively asserted claims on both sides are often purely partisan concerns. Somebody wants to get elected, and the passion of politics can be mistaken for a passion for principle. I think we understand the problem. Democratic voters tend to be younger and less likely to turn out, so it's in the Democratic Party's interest to make voting as easy as possible. Meanwhile, non-citizens and other ineligible voters are also more likely to be Democratic, so it's in the Republican Party's interest to take measures to ensure that only qualified voters are able to vote. Both these goals are entirely worthy when presented openly and honestly. But in our imperfect world, it is impossible to achieve perfection in one without sacrificing the other. We obviously need reasonable and diligent efforts in pursuit of both goals and to try to make those conflict as little as possible. What we don't need and what we see far too much of are efforts to scare decent people into believing that somebody's trying to send minority voting rights back to the Stone Ages, or wild claims that we're in a science fiction world where voting machine manufacturers are nefariously manipulating vote tallies via secret wireless networks. Those who try to whip up fear are not looking out for the welfare of minorities or the welfare of anyone else. I appreciate all the testimony we're going to be hearing today. I've read through the written testimony, and almost all of it is very measured and useful. But I would urge a few of our witnesses to try to tone down the rhetoric a little. Thank you.
Thank you, Commissioner Harriet. And I'll pass the mic to Commissioner Degblay, at whose impetus we have held this briefing.
Good morning, Madam Chair, and thank you to our assembled witnesses and guests. I would like to thank the staff for making this field briefing possible. I would also like to thank all of our witnesses from a range of views who have traveled from near and far to be here today and will be with us over the course of the day. I'm very pleased that the Civil Rights Commission has taken up this subject of Voting Rights Act enforcement as our statutory enforcement report for 2018. And I'm pleased about that for a number of reasons. Principally because the VRA tells us something about the American story. We know many things about our history. And one of the things that we know is that although we have embraced for a very long time high constitutional principles, too often our practices have not lived up to our principles. And the VRA in that sense is understood by many to be one of the most important congressional enactments of any kind, in part because it is the vehicle through which we keep the promise of our Constitution, through which we enforce the 15th Amendment and see that voting rights are accessible and there to be used by all of our citizens. I'm also pleased that we are taking this up because in that sense, the VRA is an exemplar of the sense in which our democracy is aspirational. That is to say, it can become better through hard work and through vigilance. And I think the story of the VRA, as we may hear from our witnesses today, from a range of perspectives, the story of the VRA is that vigilance in a democracy must be nonstop. Finally, I would like to say that there is a very important and simple idea that undergirds the VRA, the Voting Rights Act, and that is that a democracy is stronger when it embraces a minority inclusion principle. There are two ways to think about elections in a democracy. Perhaps there are more, but there are at least two. And because of the shortness of time, I will put them in two buckets. One way is to think of a democracy as a contest to mobilize people that share your views and to prevail on that basis. Another view of democracy is the idea that the way to prevail in an election is to prevent some people who may not share your views from participating. I dare say that the VRA is about a choice to compete on ideas and on the basis of minority inclusion. And I think for that reason, it is a very important part of our history. I'm very excited to hear from our witnesses because I think that we share one idea. And that idea is that democracy is the lifeblood of the United States of America. And that in some sense, we must be vigilant. We may have different ideas about what vigilance requires, but I look forward to being illuminated on these points by our witnesses. And again, I thank them for coming today to North Carolina, a state which has been a field where these voting rights contests have occurred from the Reconstruction period forward. And so I think that it's appropriate that we've chosen a field briefing in a state that is continuing to grapple with these very ideas. And while the view that we take today is national, it sometimes is important to think about it in particular contexts. And I welcome the witnesses to both expand with big ideas and also with some specific examples about what the state of progress is today. The Voting Rights Act is about the idea that because we've made progress doesn't invite us to stop making progress. Instead, it's an invitation to make more progress and to remain vigilant. I thank you.
Thank you, Commissioner Degbolet, and also many thanks to Commissioner Yaki, who is about to celebrate his 13th year of service to this commission and whose expertise in voting rights has been a strong guide in shaping today's briefing. I'll turn us now to begin our briefing with a few housekeeping items, the first of which and the strongest of which is deep thanks to our commission staff who researched and brought today's briefing into being. They are LaShonda Brenson, Maureen Rudolph, Sarah Lee Sewell, in addition to Teresa Adams, Carolyn Allen, Catherine Colleton-Gonzalez, Pam Dunstan, Latrice Fauché, Abir Hamid, Tina Louise Martin, David Musat, Lenora Strasky, Sarah Lee Sewell, Brian Walsh, Merrick Xavier Breyer, and Michelle Yorkman-Ramey for preparing and making the logistical details for today's work. I caution all speakers, including our commissioners, to refrain from speaking over each other for ease of transcription and to allow for sign language translation to my right. For any individuals who might need to view the sign language translation, there are seats available in clear view. Everyone present, please silence your phones and do not take flash photos to minimize health risks to persons present. After our 4 panels and an afternoon break, we will reconvene at 6 p.m. for a public comment period. If you are interested in participating in the public comment period, during which each person will have up to 3 minutes to speak, we will be honored to hear from you. In total, the oral public comment period will last 2 hours with 40 slots allotted on a first-come, first-served basis. You may sign up at the registration desk at our first break at 10:40 a.m. or during the lunch break at 12:20 p.m. The first 20 spots out of 40 total will be available until filled. We will open up registration for the second 20 spots in the afternoon break at 2:50 p.m. and if spaces remain available again after the briefing concludes at 4:30. Again, the spots will be available until filled. For any member of the public who would like to submit materials for our review, our public record will remain open until Monday, March 19, 2018. Materials can be submitted by mail to the U.S. Commission on Civil Rights, Office of Civil Rights Evaluation, 1331 Pennsylvania Avenue Northwest, Suite 1150, Washington, D.C. 20425, or by email to votingrights@usccr.gov. During the briefing, each panelist will have 7 minutes to speak. After each panel presentation, commissioners will have the opportunity to ask questions within the allotted period of time, and I will recognize commissioners who wish to speak. I will strictly enforce the time allotments given to each panelist to present his or her statement, and you may assume we have read your statements, so you do not need to use your time to read them to us as your opening remarks. Please do focus your remarks on the topic of our briefing. I also note that we have a very tight schedule today with nearly 24 experts who will speak before us. I ask my fellow commissioners to be cognizant of the number of panelists and the interest of each commissioner in asking questions. Please be brief in asking your questions so we can move quickly and efficiently through today's schedule. I will step in to move things along if necessary. Panelists, please notice the system of warning lights that we have set up. When the light turns from green to yellow, that means 2 minutes remain. When the light turns red, panelists should conclude your remarks so you do not risk my cutting you off mid-sentence. My fellow commissioners and I will do our part to keep our questions and our comments concise. Just before turning to our first panel, I understand Commissioner Yaki has some brief remarks.
Thank you very much, Madam Chair. And as you said, it's been, this will mark my 13th year on the commission. This will probably be about my 5th hearing on some aspect of voting rights, but the first since the Shelby decision. I just wanted to say something really briefly. One, thanks to Commissioner Diba-Degbele and his staff for helping to put this together. We co-sponsored this, but he really took the laboring oar as the expert on this. The Voting Rights Act was enacted not simply to give the disenfranchised a chance to vote. It was enacted to give meaning to that vote. And I think part of what we're going to be hearing today is about whether or not that meaning still exists in a post-Shelby world. But the one thing I do want to say is that hasn't been said yet, is that whatever we do here today, whatever report we put out, we as a commission are the watchdog. We're the ones who are out there telling Congress and the American people what is going on and what should be. But ultimately, it is up to Congress to take action. And ultimately, it's up to the American people to get Congress to take action. So there's a little bit of strange circular logic to all of what we're doing here today when we talk about minority disenfranchisement and the inability for minority voters to have access to the ballot and to elect minority candidates, when that very lack of access has an impact at the level of government where change needs to be made. So I just want to point that out to everyone, that there's a bigger universe and a bigger job left to all of us. We will do ours, but there are others who have to take up the oar after us to make it meaningful. Thank you.
Thank you, Commissioner Yaki. Now we'll turn to our first panel. The order in which our panelists speak includes Peyton McCrary, who served as a historian in the Civil Rights Division of the Department of Justice until his retirement in 2016. Vanita Gupta, President and CEO of the Leadership Conference on Civil and Human Rights. Ms. Gupta served as DOJ as Principal Deputy Assistant Attorney General and head of the Civil Rights Division from 2014 to 2017. Hans von Spakovsky, manager of the Election Law Reform Initiative and senior legal fellow at the Heritage Foundation. Earlier in his career, Mr. von Spakovsky served as counsel to the Assistant Attorney General for Civil Rights. Justin Levitt, professor of law at Loyola Law School, Los Angeles. Professor Levitt served as Deputy Assistant Attorney General in the Civil Rights Division at DOJ from 2015 to 2017. And Bishop Dr. William J. Barber II, President and Senior Lecturer of Repairers of the Breach. I note that Jerry Hebert, Senior Director of Voting Rights and Redistricting at the Campaign Legal Center, was scheduled to speak today. He unfortunately is unable to be with us, but his written statement will be added to the record for the Commission's consideration. Mr. McCrary, please begin. You need to turn your microphone on for pushing the large button. Thank you.
Thank you. Let me begin by thanking the Commission for inviting me to participate in this important hearing on current challenges in voting rights enforcement in the United States. My remarks reflect my training as an historian and an historian who unusually has worked on voting rights litigation for 37 years. I also grew up on the Virginia-North Carolina border, and when I registered to vote for the first time in 1964, I had to pay a poll tax and take the receipt to the polls with me, which tells you that I'm old. It seemed to me the most useful thing for me to tell the Commission is about the experiences of the Department of Justice and private plaintiffs in recent voting rights litigation in cases that were decided after Shelby County versus Holder, and which in a couple of cases began before the Shelby County decision, which helps to illustrate the differences between the Section 5 process of litigation and litigation under Section 2 of the Voting Rights Act. I emphasized in my written testimony these three cases: the North Carolina case challenging the omnibus election law adopted in the immediate aftermath of the Shelby County decision, in which the legislature made clear that it was acting because the preclearance review process was no longer present, and therefore they expanded the bill to include a number of provisions that the Fourth Circuit Court of Appeals found to be racially discriminatory in intent and effect. Two cases from Texas that I was also heavily involved in involved one, the redistricting plan adopted by the state in 2011 for congressional, state Senate, and state House plans, and also a case involving the photo ID requirement adopted by Texas in 2011. The focus of my work on all cases, including these cases, was on the fact-finding done by the department and the identification of appropriate expert witnesses to use in addressing the empirical issues before the court. And that's the focus of my written remarks as well. The importance of expert witnesses in voting rights litigation has long been a little understood part of the process, and that was true in these recent cases as well. Expert witnesses testify about matters that the court either doesn't have the technical skill to address or which the court may not have the time to address. And in doing so, the experts use their training as social scientists in most cases to assemble evidence that is credible according to the basic social science methods in their discipline. And that's, of course, what we were doing in these three cases. Putting on these cases is enormously expensive, even at the local level. These three cases involved laws of statewide application and were even more labor intensive and therefore resource intensive than a local case. It occupied much of the work of the Justice Department in the years after 2011, and only in part of that time, of course, were the resources of the voting section and the Civil Rights Division also available to address preclearance review under Section 5 of the Voting Rights Act. These cases demonstrated in the instance of the two cases challenging photo ID requirements that legislatures were acting on the professed belief that in-person voter fraud at the polls was a major problem facing their states. In the cases, there was never any evidence that persuaded any of the courts that this was empirically correct. Instead, the courts tended to view this claim as pretextual. In some of those cases, the states also offered the view that it was necessary to address voter fraud by adopting rigorous restrictions on the use of, on the identification of voters through requiring photo ID documents in order to address the concerns about voters, that the process didn't operate in a fair and equitable manner. The states were never able to persuade the courts that this was a claim based on any empirical evidence as well. It proved to be necessary to develop new techniques in order to address the photo ID requirements using political scientists who were experienced in large-scale database matching to address problems in election administration. It was very time-consuming. It was difficult to do. It required complex analysis, but in all cases, the database matching methodology was effective in presenting this evidence to the courts. A further difficulty in database matching, where the laws required certain federal or allowed certain federal documents to be used as identifying voters, was the need to coordinate with a variety of federal agencies who issued those documents, and that was impossible to do during the Section 5 time frame where courts proceed on a very rapid discovery schedule. But in the Section 2 litigation, it was possible to coordinate all those agencies to assemble all the evidence and the record speaks for itself in those cases. One of the problems with the focus on these statewide cases is that local cases tended to fall by the wayside. And of course, it was local issues of voting rights that were addressed most effectively under Section 5 of the Voting Rights Act when it existed. And it's very difficult to imagine Section 2 litigation being able to address those many local changes that only the preclearance requirements of the Act enable the department to address. At any rate, we are now in a place where the only effective remedy that can replace Section 5 is Section 3C of the Voting Rights Act,
Thank you,
which
Professor
requires
Foster
proof
McCray.
of discriminatory intent.
Thank you. Ms. Gupta, please proceed.
Good morning. Thank you to the commissioners for inviting me here today to speak with you. As the head of the Leadership Conference on Civil and Human Rights, we've been involved. We were founded in 1950 and have coordinated national lobbying efforts on behalf of every major civil rights law since 1957, including the Voting Rights Act of 1965 and its subsequent reauthorizations. During the last 2.5 years of the Obama administration, I led the Justice Department Civil Rights Division. The Supreme Court's devastating Shelby County decision in 2013 dramatically weakened the government's ability to prevent efforts to disenfranchise voters, and it emboldened some states to pass voter suppression laws, including restrictive photo ID laws, cutbacks on early voting hours, and elimination of same-day registration. And thankfully, a number of federal courts have struck down several of these laws, and striking down the North Carolina law that my co-witness Peyton McCary just spoke of in July 2016, a law that was enacted very shortly after the Shelby County decision came down. The Fourth Circuit described the law as, quote, the most restrictive voting law North Carolina has seen since the era of Jim Crow, with provisions that, quote, target African Americans with almost surgical precision. There have been findings of intentional discrimination in at least 10 voting rights decisions since Shelby County. And I just want to make a few top-line observations with the time that I have about the impact of Shelby County on DOJ's enforcement. One is that the loss of preclearance means that the Justice Department now must use Section 2 to affirmatively sue jurisdictions that engage in discriminatory election practices. The litigation is slow. It is enormously time intensive. It ties up very precious resources. It can take years for a case to make its way through the courts, as is exemplified by both the North Carolina and Texas litigations. And all the while, elections are happening and harm is being done to the public as a result of these discriminatory laws being in place. Preclearance, of course, was designed to stop discrimination before the discriminatory rules went into effect. And now the harm is ongoing, and the statewide litigation challenges that the Justice Department has been engaged in North Carolina and Texas ate up a really significant amount of Justice Department attorney resources and time. The second consequence of the Shelby County decision is that it has become increasingly very, very difficult to track changes in local election practices at the county level, villages, state boards, and the like. And what some folks don't kind of remember is that actually the vast majority of objections that were lodged by the Justice Department under Section 5 between 2000 and 2013 concerned county and municipal, school board, and special district election changes. And so there is a very real consequence that local discriminatory changes are not being tracked, discovered, or addressed since Shelby County. The third consequence is that the Justice Department has interpreted the Shelby County decision as also curtailing election observers because the observers have been dispersed according to the same Section 4B formula that the Supreme Court found throughout in its Shelby County decision. And this has had a very significant impact on the ability to gather evidence of problems, particularly in Section 203 and Section 208 cases, which often depend on direct observation of what's happening at the polls themselves on the day of elections. And then a fourth consequence is also the very significant impact that we have not yet seen and that we will come right after the 2020 census. This is now going to be the first time when Section 5 is not in place to block or deter discriminatory voting changes in redistricting plans. And so in order to meet the Constitution's one person, one vote requirement, thousands of redistricting maps from statewide, congressional, and legislative maps to county and city council district lines are going to be redrawn in jurisdictions that were previously covered by the Voting Rights Act pre-clearance requirement. And following the 2010 census, the Justice Department reviewed more than 2,700 redistricting plans from covered jurisdictions. This upcoming round of redistricting will mark the very first time in 5 decades that discriminatory maps are going to be enacted with no prophylactic review and can only be challenged after the fact in very time-consuming and expensive litigation. I will also note that the Justice Department's shifting priorities under the charge of Attorney General Jeff Sessions have created quite a cause for alarm in undermining also the aggressive enforcement of the Voting Rights Act. In February, the Justice Department reversed its longstanding litigating position that the Texas voter ID law was intentionally racially discriminatory, even though no new factual evidence had arisen to undermine the position that the Justice Department had taken in court for the past 5 years. In addition to that, there have been a lot of concerns about what this Justice Department may be signaling with regards to enforcement of the National Voter Registration Act in a letter that was sent in July, where the Civil Rights Division sent a letter to 44 states asking for the first time extensive information exclusively about how states maintain their voter rolls. The department's longstanding practice has been to send letters of this kind only where there is particularized evidence of possible noncompliance by a particular given state, and sending an investigative demand letter to every NVRA covered state in the country is certainly a highly unusual move that appears to be a prelude to voter purge efforts. And then in August 2017, the Justice Department filed a brief in the Husted versus Afeld Randolph Institute case, arguing that it should be easier for states to remove registered voters from their rolls. In so doing, it reversed a consistent, longstanding legal interpretation of the NVRA that had been enacted since 1993, and also reversed a position that the Justice Department had taken in lower courts in precisely the same case. I think there's no question that American voters need Congress to restore the Voting Rights Act to its full and proper strength post-Shelby County. Shelby County made clear that a new preclearance system must be tailored to current conditions, and the Voting Rights Advancement Act is one way that could create a new coverage formula and restore Section 5 of the NVRA. As all of you know, in closing, 2006, the Voting Rights Act was reauthorized with strong bipartisan support. This issue needs to remain bipartisan even in these highly polarized times. Thank you.
Thank you, Ms. Gupta. Mr. Von Stokowski.
Good morning, and thank you for inviting me here. I was asked to answer a series of questions, but in summary, I would say that after Shelby County, the Voting Rights Act remains a powerful statute whose remedies are more than sufficient to stop those rare instances of voting discrimination when they occur. Now, the question was, has the Shelby County decision affected the DOJ's voting rights enforcement of Section 2, Section 203, and Section 208? My analysis of that is the answer is no. If you look at the litigation record of both the George W. Bush administration and the 8 years of the Obama administration, what they show is a sharp overall downward trend in the number of enforcement actions filed, including after 2013, the year of the Shelby County case. For example, Section 2, which is the nationwide permanent provision of the VRA that prohibits racial discrimination in voting. The Bush administration filed 15 cases to enforce Section 2. Only 3 of those were in jurisdictions covered by Section 5, South Carolina, Georgia, and Mississippi. The Obama administration, 8 years, only filed 5 cases to enforce Section 2, only about a third of what the Bush administration did. 3 of those were in jurisdictions covered by Section 5, Texas covered in whole, and North Carolina. The Obama administration thus filed far fewer Section 2 enforcement cases. But the number of cases filed in either Section 5 covered jurisdictions or formerly Section 5 covered jurisdictions was exactly the same for both administrations, 3. Section 11B, which was not mentioned in your question, but which is another important provision because it prevents coercion and intimidation in the voting prospect, the Obama administration filed no such cases to enforce that provision. The Bush administration filed 2. The VRA has two language minority provisions. The Obama administration filed 8 lawsuits and entered into 2 settlement agreements for a total of 10 enforcement actions. Only one of those occurred after 2013, a settlement with Napa County, California, which was not covered ever under Section 5. The Bush administration filed 27 lawsuits and 1 settlement agreement for a total of 28 enforcement actions. Again, the Obama administration only filed about a third of the number of cases the Bush administration did to enforce the language minority provisions. Section 208, which the commission also asked about, is a provision that protects voters who need assistance because of disability, blindness, or inability. The Obama administration only filed 1 case in 8 years to enforce that provision. In 2009, 4 years before Shelby County, no enforcement action was filed after Shelby County. By contrast, the Bush administration filed 10 cases, only 2 of which were filed in a jurisdiction covered by Section 5. Thus, the litigation record does show that these provisions have continued to be enforced, but there's been a sharp downturn in the last 8 years in the enforcement actions filed. Now, this was obviously not due to a lack of personnel or resources, since the staff of the voting section who had worked on Section 5 matters were not terminated. In fact, they were all retained after Shelby County, which meant that they could be used for these other cases. Also, the Civil Rights Division's own budget performance report shows that their appropriations steadily increased from $136 million in fiscal year 2013, the year Shelby County was decided, to $175 million in 2016. Thus, the downturn seems to reflect a reduction in the discriminatory actions that would justify a DOJ lawsuit. The other question was, is the federal preclearance process a system that should be reinstated? The answer to that is no. In 1965, Section 5 was needed. There was official, systematic, widespread discrimination that kept Black Americans from voting. Section 5 was put into the law in addition to Section 2 for one reason. The reason was that there was blatant evasion of court decrees, even when the Justice Department won cases, and that's why the preclearance provision was put in. But times have changed, and as the Supreme Court said in Shelby County, today, blatant evasion of a court decree is extremely rare. Judge Stephen Williams of the District of Columbia Court of Appeals pointed out in the Shelby County case in the lower court that in fact the jurisdictions covered under Section 5 had higher Black registration and turnout than non-covered jurisdictions. Covered jurisdictions also had far more Black office holders as a proportion of the Black population than did uncovered ones. And in a study of lawsuits filed under Section 2, Judge Williams found that the 5 worst uncovered jurisdictions had worse records than 8 of the covered jurisdictions. With no evidence of widespread voting disparities among the states, continuing the coverage formula unchanged in 2006 was irrational. Again, going back to the key point, Section 5 was there because of evasion of court remedies, court-ordered decrees in the 1960s. Because that is so rare today, and because there's no discernible difference between states other than the formerly covered states actually have better records these days, there's no reason for Section 5 to be put back in as a blanket coverage, particularly because we have Section 3. Section 3 is a custom-made version of Section 5. If a court believes that a particular defendant is not only engaging in discrimination, for example, under Section 2, but is a recalcitrant defendant, someone who is feared may repeat this behavior, they can be put into a specific pre-clearance requirement. I am aware of only 2 cases that's happened since 2013, one involving the city of Evergreen, Alabama, which was formerly covered jurisdiction, and another one covering the city of Pasadena, which was never covered under Section 5. To conclude, there's no reason, given the custom provisions of Section 3, to reinstate Section 5. And in fact, there's no evidence that particular states are engaged in systematic official discrimination that would justify treating them differently from other states. Thank you.
Thank you, Mr. Von Spakovsky. Professor Levitt.
Thank you, Madam Chair. Thank you, Madam Chair, Madam Vice Chair, distinguished commissioners. Very much appreciate the opportunity to testify before you today to supplement my written statement and answer any questions that you may have. The Voting Rights Act that was enacted on a bipartisan basis by Congress was a relentlessly pragmatic tool that was designed to enforce a cherished American commitment to equitable representation, as Commissioner Degbele said, to keep the promise of the Constitution. Shelby County, in my view, ripped a significant hole in Congress's work. Despite the best efforts of private attorneys and the civil servants of the Department of Justice, Shelby County has left Americans less able to timely defend themselves against voting discrimination, plain and simple. Unfortunately, in the past few years, a few jurisdictions have amply demonstrated that existing tools, while powerful, are nevertheless inadequate, even with armies of lawyers. I fear that the worst is yet to come. Shelby County is so significant because it gutted a procedure uniquely tailored to a unique problem. Most civil rights litigation, as you know well, is responsive. If there's a legal problem, you sue, you prove harm, the problem gets fixed for the future. But election laws and enforcing the voting rights provisions of federal law are different. Discriminatory election laws artificially tilt the terrain by which officials hold office. Because these discriminatory procedures may help officials keep their jobs, they're often willing to fight tooth and nail even when the illegality becomes strikingly clear. When officials do dig in, they don't bear the costs of this extreme resistance, the taxpayers do. And when the taxpayers disapprove, they can't toss the offenders out of office because the election rules themselves are the problem. In no other civil rights arena is the impact on officials so personal and direct. Election laws are different. Normal lawsuits, as you've heard, are also a little bit like ocean liners. They're very complicated, they're very expensive, they're very slow to get going. Voting lawsuits, and particularly suits under Section 2 of the Voting Rights Act, are an extreme version, among the most complicated in the federal system. The Federal Judicial Center did a study a number of years ago of the 63 categories of federal cases. Voting cases rank sixth most complex. It can take years to develop evidence, years to resolve. Enforcing the voting laws is different. And in the meantime, elections infected with discrimination are taking place. We know that elections have consequences. Discriminatory elections have consequences too. The winners of unjust contests still become incumbents and still end up making policy. And even if you can eventually get the election structure right, that doesn't fix the policy of the meantime. Election laws are different. Unfortunately, these aren't just theories. We're in North Carolina, and I expect that you'll hear plenty about North Carolina today. And so I want to use my limited time. There's plenty to hear in that regard. I want to use my limited time to give you a different example from outside of the jurisdiction where we sit and where you're likely to hear public comment later. So instead, I'll just briefly mention an example from Texas. When it comes to racial misconduct, Texas has unfortunately proven themselves to be an unrepentant recidivist, one of the recalcitrant jurisdictions that Mr. von Spakovsky mentioned. After decades of trouble, after a Supreme Court decision specifically railing against conduct bearing the indicia of intentional discrimination, Texas drew districts again determined by multiple courts to be discriminatory. Some of the lines that they drew were found to be intended to discriminate. And at the same time, the same legislature passed a restrictive ID law, also found to be intentionally discriminatory. Mr. von Spakovsky mentioned in his written testimony that no one can rationally claim there is still widespread systemic official discrimination in any of the formerly covered states. I simply don't know what else to call this pattern. And though blatant evasion of court decrees is indeed rare, more subtle evasion is strikingly still present and pernicious. Preclearance blocked effectively both of the policies that I just mentioned, both the ID law and the redistricting law in Texas. But Shelby County kicked open the door. The 2012, 2014, and 2016 elections, primary elections and general elections, for Congress and for the State House were all held in districts determined to be discriminatory. Those elections cannot be undone. An army of lawyers arrived, including lawyers from the Justice Department, to try to fill the gap Shelby County left, and that litigation, which has consumed enormous resources, is still ongoing. Given its schedule, it is extremely likely that the 2018 elections will also be held under invalid lines. And Section 3 relief, if it is ever to come, will come a decade too late. That means that justice has been repeatedly delayed in Texas, which means that justice has been repeatedly denied in Texas. Enforcing the voting laws is different, and as Congress recognized, the existing tools are simply not enough. And if that's true for a statewide problem, along with both Mr. McCrary and Ms. Gupta, it's even more concerning for the tens of thousands of local jurisdictions. That's where it's most difficult to find out about the problems in the first place, and where those most at risk have the least resources to fight back. The country's early warning and rapid response system for many local concerns was dismantled by Shelby County, and the 2020 redistricting is around the corner. I had the honor to serve at the Department of Justice, supporting the efforts of enormously talented experts and lawyers to correct what problems they could in this new environment in ways that are not always revealed by more facile numerical comparisons. And I look forward to getting into some more of the detail if you have questions about the numbers cited by Mr. Fonspakowski, including, I think, at least 2 factual inaccuracies. Some of these issues are resolved before they ever become cases, and some are resolved in negotiated settlements. But the department's capacity to discover wrongdoing has been severely hampered by Shelby County, and once found in too many matters, it takes too long to develop proof, too long to fight to a liability finding, and far too long to get a remedy. The Supreme Court invited Congress to remedy the damage done by Shelby County. I know that your work will help facilitate that. I look forward to answering any questions toward that endeavor you may have.
Thank you, Professor Levitt. Bishop Dr. Barker.
Thank you so much, and thank you to the commission for allowing me to testify today. Isaiah 10 says, "Woe unto those who legislate evil and rob the poor of their rights." We are living in a time when voters of color have increasing potential for political power. Nearly 30% of America's eligible voters are people of color. And African Americans, Latinos, Asian Americans, whites, and others are coming together in historic numbers to form fusion coalitions. But we are also living in a time when we are seeing, particularly across the South, the worst redistricting and abridgment of voting rights since the 19th century. Without the protection of the Voting Rights Act, pre-clearance provisions, Jim Crow era voter suppression efforts are reappearing in North Carolina and in too many other states across the country. The wave of voter suppression, which has disproportionately impacted voters of color, imperils the confidence of all voters of goodwill and strikes at the very heart of our democracy. It was a lie in 1965 when people argued against the Voting Rights Act by saying systemic racism was a thing of the past. It is a lie in 2018 for those to say that systemic racism is a thing of the past. Since 2008, at least 22 states have enacted a new statewide voter suppression laws, and in 2017, at least 99 additional bills proposing such measures were introduced in 31 states. Here in North Carolina, when North Carolina's 15 electoral college voters went to America's first Black president in 2008, it sent shockwaves through the racially polarized white-dominated Republican Party in North Carolina. Their Southern strategy had failed to deliver in 2008. Immediately, what we saw was right-wing extremists scramble to invest unprecedented sums of money in state legislative races, resulting in an extremist takeover of North Carolina's government. The majority that took over North Carolina's General Assembly quickly redrew both state legislative district and U.S. congressional districts in their favor. They claimed that they did it just like Democrats, but 2 things should be noted. One, some civil rights organizations have always challenged every party, and 2, we had not seen this kind of attack of stacking and packing since the 19th century. They consolidated power. The 2011 districts segregated white and Black voters by mechanically adding Black voters to election districts in concentrations not authorized or compelled under the Voting Rights Act, thereby bleaching adjacent districts of voters of color and frustrating their ability to vote in alliance with a growing multiracial fusion electorate that bridges racial divides and mitigates the effects of racialized polarized voting. These very laws were overturned by the current court. They were called unconstitutional. But what it took so long to do that we had an unconstitutionally constituted legislature, an unconstitutionally constituted legislature. We won, but it was only after this group was in power and had begun to strike down many of the advancements that had been made. It was devastating in 2013 when the Supreme Court gutted the heart of a critical piece of civil rights legislation in Shelby County versus Holder. At the date of the Shelby decision, 15 states were covered by Section 5 in whole or in part. North Carolina was one of that. Even with the full protections of the Voting Rights Act, had been a struggle in North Carolina. In the 30 years prior to Shelby, the U.S. Department of Justice objected more than 60 times to more than 150 voting changes in North Carolina. After Shelby, one of our legislators actually said, now that the headache has been removed, and they moved forward with a full bill within hours of the 2013 Shelby ruling. They rolled out a sweeping omnibus voter suppression bill that erected a slate of stringent racially discriminating barriers to the ballot. The laws eliminated things that voters had already used, such as same-day registration, pre-registration for 16 and 17-year-olds, out-of-precinct ballots the first week of early voting, and instituted one of the nation's most stringent photo ID laws. We called it the Monster Voter Suppression Law. In response, the Forward Together movement erupted. Over 1,200 people, many of them white, were engaged in nonviolent civil disobedience. And after years of organizing, the courts finally struck down this intentionally racially discriminatory law and said that it was almost surgical precision to impose cures for problems that did not exist, no matter how many experts or so-called experts claim that they do. And this Supreme Court denied the leadership of the North Carolina General Assembly any petition for further. It is interesting that Attorney General Sessions, one of his first acts was to actually pull the U.S. Department of Justice out of the defense of the voters of North Carolina. Lastly, I would say, however, despite the Fourth Circuit's ruling requiring the restoration of the first 7 days of the early voting period, North Carolina Republican Chair Dallas Woodhouse produced and distributed a memo to Republican members of the county boards of election, instructing them to make party line decisions in drafting new early voting plans, including voting against Sunday hours for voting and maintaining decreased numbers of hours at sites, particularly on weekends. This resulted in 2016, 158 fewer old early voting sites in the 40 previously covered counties than we had in 2012. This is another example of blatant evasion, of blatant attempt to block the power of the African American and minority vote. What we have seen is systemic racism, and we know that it is time past for the full restoration of the Voting Rights Act. We have seen this Congress since 2013 engage in a modern form of interposition and nullification and hold up passing and refixing the Voting Rights Act for nearly 2,000 days. To talk about racism, just think of it in this historical context. Strom Thurmond only filibustered the Civil Rights Act of 1957 for 1 day, 24 hours. This Congress has engaged in a filibuster of over 1,700, nearly 2,000 days. We need full restoration of the Voting Rights Act.
Thank you, Bishop Dr. Barber. I'm going to now open the conversation to my fellow commissioners, beginning with Commissioner Asaki.
Good morning, everyone. I have a lot of questions, so I'm going to ask you to keep your questions short because we only get to so many minutes. First, Ms. Gupta, you talked about the importance of monitors and what the Shelby decision did in terms of the Department of Justice's ability to use them. So there are observers and monitors, which I always get confused. Some of them are still being fielded. It seems to me that the observers were able to do a lot more than the monitors. Could you explain the difference and how the changes has undermined the ability to enforce the Voting Rights Act?
Yeah, so you're correct that there's a difference between the monitors and observers. The observers were allocated in significant numbers pursuant to the Section 4B coverage formula and had much greater power to be inside the polling sites in a way that the monitors are not. The funding, this is a little bit wonky, but the way that the funding comes to the observers versus monitors means that there was specific stream of funding that allowed for a high number of observers in all of the polling sites covered by preclearance. When we were making the decision about allocation of monitors in 2016, the number was down to by hundreds and hundreds in terms of placement of Justice Department trained monitors who could only be outside of the polls. And that grossly, as you can imagine, inhibits the kind of information and evidence collection that can happen when people are not physically inside the polling sites to observe ways in which voters might be unable or being challenged unlawfully in exercising their right to vote. And so it's had a dramatic consequence, I would say, on the ability of the Justice Department to actually get the kind of evidence they need to make these cases.
I can see that when I used to work on these issues, I was meeting with the then Lieutenant Governor of Hawaii on Section 203 enforcement, and they insisted that bilingual assistance wasn't necessary. And I said, what was their evidence? And they said, well, we keep getting the translated materials back still in their shrink wrap, which meant to me that they never put them out in the first place, which is something you can't observe unless you're there. Mr. Levitt, it seems to me a lot of people don't know that there were actually several legislative attempts before the 65 Act to try to stop the voter suppression that was going on. And the genius of Section 5 preclearance was based on seeing local officials create new barriers every time a court said you can't do this. So it wasn't necessarily blatant disregard, it was more subtle ways of evasion. You observed in your testimony that there's still subtle forms of evasion. Can you give some examples of what's going on? Is that still happening?
Certainly. So unfortunately, yes. And even more unfortunately, I think that the ability of the Department of Justice and the ability of private observers to know all of the ways in which it's happening, particularly on a local level, has itself been hampered. Some of the examples that we've seen involve acts that are passed with what has been later found to be discriminatory intent on the eve of a trial, which has taken years to accumulate the evidence for, and which has taken years to prepare, immense amount of resources. The legislature will adjust the law just enough to try and fly below the radar of what is provable. That is, having set out to discriminate against voters on the basis of race or ethnicity, only when their feet are held to the fire on the eve of litigation will legislatures then attempt to not correct the problem, but modify the laws just enough to make it even more difficult to prove in litigation. We saw this, unfortunately, right here in North Carolina. In North Carolina, as several witnesses have mentioned, there was a bill that was designed before Shelby County. The moment that Shelby County was enacted, legislative leadership turned to what they called the full bill, a vastly expanded and vastly more discriminatory omnibus set of restrictions. Litigation commenced and was vigorously being contested. And a month before trial was set to begin, the legislature revised their law a bit, not completely, not striking it down, but revised it just a bit. That itself delayed litigation of the further proceedings. What we're seeing is increasingly sophisticated and increasingly they may not be quite as blatant as in the years in which Mr. von Spakovsky mentioned, but there are still certainly efforts by the legislature not to do right by their constituents, but to do just enough to skate by beneath the guise of a federal court. That is not what the Voting Rights Act was intended to further. Indeed, it was intended to stop exactly that sort of gamesmanship.
Thank you. Mr. McCreary, some of the witnesses today in the written testimony are seem to be arguing that the lack of explosion of Section 2 litigation is somehow itself indication that Section 5 is no longer needed. What is your response to that? Is that the real measure of whether Section 5 is needed?
No. As several of the panelists, including myself, indicated, litigation is time-consuming, resource-intensive, and that slows down other kinds of enforcement. Plus, the unavailability of preclearance review means a lot of things were happening that we don't even know about at the local level, potentially. Things that were monitored under the preclearance process before Shelby County was decided. And to take the verdicts in court decisions challenging discrimination as the sole evidence as to whether discrimination is happening doesn't make a lot of sense to me as a social scientist.
But Bishop Barbara, it looked to me like you may have had an answer to one of those questions, or am I misreading your body?
Just a couple of comments, and I'm only standing because of a long-term bad hip. There are a couple of things I'd like to just mention. One is when we went to federal court, one of the justices asked a very powerful and simple question, yet profound, to those who were fighting against the voting, to roll back these voting laws. Why don't you want people to vote? And the courtroom got very quiet. Federal judge said, why is it that you're fighting? Because the provisions in North Carolina, same-day registration, early voting, were things added that people had already used for several election cycles. There was no fraud, but the one thing there was an increase in African-American and Latino and other minority voting. What we saw is, in this case, it was blatant. They were caught by this Supreme Court, not by an earlier Supreme Court, but the very Supreme Court that undermined Shelby had to say these laws in North Carolina were so racist and so surgically racist, and it was proven as such that the only things they touched were the areas where it was clearly shown that minority voters were able to overcome past discrimination. Last two things. We have 340 years of slavery and Jim Crow. We've only had 52 years of the Voting Rights Act, and all 52 of those years have been fights to undermine it. It took 25 years after the passage of the Voting Rights Act before North Carolina even got another congressperson in the United States Congress. So it was not as though it happened quickly. And the Voting Rights Act was passed in my lifetime. I finally would just add to your question about this not the measure. Pre-clearance allowed many things not to go to court. That's the point. They didn't go to court, so you can't measure what went to court. However, when you reverse pre-clearance, what you allow is you allow laws to go on the books. You allow legislators to get unconstitutionally elected and pass laws, even though they are unconstitutionally constituted. And then you allow laws to go on the books, and they may be used for 2 or 3 election cycles only to be proven unconstitutional, which means you've had unconstitutional elections because the laws that were used in those elections are finally proven unconstitutional. Lastly, all of those saying we don't need, Section 5, and it's bad for the states, and the states this should not happen to certain states that have had a history and a contemporary reality of suppression. Last thing I would say, every state that's under the Voting Rights Act, pre-clearance, could have had it released if they did one simple thing: didn't discriminate for 10 years. Not one state has been able to resist trying, Democrats or Republicans, because we challenge both, has not been able to resist for 10 years. And that is why they are still covered or were covered under the Voting Rights Act, Section 5.
Thank you. Commissioner Saki?
Thank you, Reverend Barber. That actually reminded me of another question, which is a couple of the witnesses referred to the fact that there was surgical provision, that there was evidence of intent that courts have actually found. So what exactly was the evidence of racial intent to actually discriminate on a racial basis?
Well, I would say, and turn it to the attorneys, but I play one on Tuesdays and sometimes on Friday. But what we were actually advised by some not to go after intentional racism, to go after disparate treatment, which would still be illegal. But we knew this legislature. We knew that they had heard all of this evidence. They'd even heard some of the people on this panel that had our brother Hans had come and given them support for what they wanted to do. It was found that they actually went to the Board of Elections and asked what was the impact on the various laws, like the first week of voting, what was the impact based on race? And if the impact was positive based on race, that's what they ended up removing. They actually looked at how did same-day registration and early voting impact and increase the participation of minority voters. They asked the question in emails and whatever, and then wrote their legislation, blatantly wrote their legislation, despite the evidence and despite the lies about fraud. And for me, theologically, you know, to suppress people's vote is not only constitutionally illegal, it's theologically illegal, because the only persons that can receive voting rights are people. We don't give voting rights to goldfish and pets and puppets. So if you suppress my voting rights, you are suggesting I'm not a full person, which is a violation of the most fundamental principle of theology, and that is that we are all made imago Dei, in the image of God. To suppress the right to vote is to deny the worth and the image of God of every human being, regardless of their race, their color, or their sexuality.
Vice Chair.
Thank you very much. I too join my fellow commissioners in thanking our panelists for being with us. We're in North Carolina, and so I'm going to go in a North Carolina direction. When we think of voting rights and Section 5 and all of that, we think of statewide elections. We often think of school board elections and county commissioners or whatever. In North Carolina, we also elect our judges. And there is a discussion and possible legislation underway in North Carolina that will redraw our judicial districts. And some allege will pit some duly elected African-American Superior Court judges against other African-American Superior Court judges, thereby reducing the presence of minorities on the bench. And so I'd like for you to, in terms of Section 5 pre-clearance, talk about judicial elections and the effect. And you've been speaking, Bishop Barber. I'm going to turn to Mr. Levitt and others to comment, if you will, about that. And then I have just one other question, Madam Chair.
Certainly. Thank you, Madam Vice Chair, for the question. The Supreme Court long ago held that the Voting Rights Act, both Section 5 and Section 2, apply to judicial elections, that there is a representational equity in ensuring that if you're going to have judges elected, that you make sure that they do so free of racial discrimination, just like all other elections. I've been certainly following the broader discussion in North Carolina. I confess I do not know the intended character of the districts themselves, but this is part of the point of the impact of Shelby County, is that there will be attention to this statewide law. That I'm not worried about. For the smaller jurisdictions, we're really concerned that we won't know the effect of the change. The one thing we know is that people will focus on the impact of the law, but proving discrimination in these districts, if they in fact result, gathering the social science evidence, gathering the quantitative and qualitative social science evidence will take, experience has shown, years to prove and years to litigate. And in that period of time, if indeed districts are passed that are discriminatory, and I don't want to presume that they will be, but if in fact they are, that will affect the character of the justice that the citizens of North Carolina receive while they're waiting for a lawsuit to work its way through the system. That sort of expense and that sort of cumbersome nature of responsive litigation is insufficient to the task, I think. The Section 5 review process, abbreviated as Mr. McCurry mentioned, it was designed to get a short, quick answer on whether a particular new practice or a particular change in practice was discriminatory, that benefits both the jurisdictions themselves and those who would seek to stop those practices when they are discriminatory. And that sort of review before the discrimination takes effect is unfortunately no longer in place outside of 3 very small jurisdictions already bailed in under Section 3, as Mr. von Spakovsky mentioned.
Thank you. Would you like to add to that, Bishop Barber?
One of the things we're finding in North Carolina that Republicans and Democrats are against undermining the independency of the judiciary. What we're also seeing is that these legislators who have been unconstitutionally constituted continue, despite all of the rulings, to attempt to pass laws that they know do not have to be pre-cleared. That's the only reason they know they do not have to be pre-cleared, and they could not stand a pre-clearance test. The last 2 things I would say, this is the first time in the history of North Carolina where we have 2 African Americans sitting on the Supreme Court. This attempt to say we want to appoint as opposed to that we want to change the primaries and change the way they're elected is an attempt to undermine progress, particularly in the southern state. And I was in the 1990s, was when we in North Carolina, we had to have special elections to get African-American representations on our judiciary. That was 25 years after, over 25 years after the Voting Rights Act, and it's only been 28 years. And yet now you have this extremist legislator that know that now that districts have been ordered to be redrawn, many of them will not survive, probably will not survive. And so what are they doing? They are doing what they said in South Africa one time, only a dying mule kicks the hardest. They know that that is what is happening, and they're trying to go after every institution they can because they know they can do it without preclearance. And then once they do it, if they do it, it would take years to undo it. And that is the great undermining that has happened because of the gutting of Section 4, which nullifies Section 5.
Just one more quick question. I believe that it was Mr. Spakowski, von Spakowski, indicated that there was really no reason to reinstitute Section 5 because of the presence of Section 3, that Section 3 will handle it. What do you say, sir, to Mr. Levitt's acknowledgement of Section 3, but his indication that the relief comes too slow or too late?
You know, I constantly hear that, but that assumes that there's no such thing as a temporary restraining order or a preliminary injunction, which is granted all the time in voting cases. In fact, when I was at the Justice Department and we were engaging in Section 2 litigation, as I'm sure you're aware, Judge, that was a standard thing to seek. So if, in fact, you do have a case with merit that's likely to succeed, the idea that this is going to proceed for years, it just isn't the case if you've got the evidence to show that a TRO or preliminary injunction is going to work. One thing I want to say about the redistricting issue, and I think everyone, no matter what side of this they're on, will agree with me that redistricting is a chaotic mess. The law is particularly confused, and one of the biggest problems in this area is, and I have talked to Justin about this, so I think I should probably trademark this, but I wrote an article recently talking about the Goldilocks principle of redistricting. The reason being that jurisdictions are in a catch-22. If they've got to consider some amount of race, if they don't, then they're going to be sued under the Voting Rights Act for not protecting and looking out for minority voting rights. On the other hand, if they use too much race, they are again going to get sued, and because they're going to be violating the law under the Shaw versus Reno decision, which I'm sure you're familiar with too. So they have to use exactly the right amount. And the problem is that the view of whether you're using too little race or too much race frankly, it varies from judge to judge. People with good intentions see it differently. And so it's a very, very confusing area. And it's very tough to get it exactly right. There was a recent North Carolina case where I think the justices talked about it was the case was it was the fifth time that case was up before the court, which showed that the parties and the judges can't seem to get it right. So my point is that redistricting is a very confusing area, and the idea that everyone the idea that there's this automatic assumption that people are acting with intent to discriminate as opposed to trying to get it right. I think you've got to keep that in mind.
Mr. McCurry looked like he wanted to say something. I want to ask you, sir, if the presence or the existence of temporary restraining orders is sufficient to answer the concerns about the slow relief in connection with Section 3.
Well, first of all, I understood your question to be about Section 3C remedies, and there's no possibility of any kind of injunction triggering a Section 3C remedy because it requires a finding after full trial on the merits. There is this intentional discrimination before a Section 3 remedy can be adopted by the court. When the court adopts it, it's limited in scope and in duration. And often courts are reluctant to impose a Section 3C remedy. In the North Carolina case, for example, where there is a finding by the Fourth Circuit, the Court of Appeals, that the law was intentionally discriminatory and therefore it's eligible for a Section 3C remedy, the court didn't order one.
Ms. Gupta, looked like you had an answer as well.
Yeah, I was going to mention what Pete McCrary just mentioned, but also on top of that, I think it's important when Mr. von Spakovsky says that courts, that race is hard and what the evidence is and threshold is hard. And it is Section 3, it really bears emphasis that it relies on individual determinations on findings of intentional discrimination, and the bar for those findings is incredibly high. Congress has opined on this, opined on it recently, and that even amidst ample circumstantial evidence of wrongdoing, that proof of intentional discrimination really is exceedingly difficult to obtain. And so to make those cases, it's not only that you can't get the kind of injunctive relief that was previously referred to, but actually that the bar itself is incredibly high, and that is a vastly different regime and framework than what the pre-clearance regime would have done. And to the Vice Chair's point earlier, the harm, yes, it's intensively resource intensive and expensive to do litigation, but I want to again bear emphasis that the harm at that point is already done. And that is in essence one of the core differences between what existed before Shelby and what exists now. Is that we then have elections, we have judges, we have systems in place that are infected with racial discrimination that are allowed to persist even during the pendency of litigation, and voters are harmed. People who interact with the local justice systems that are infected with unlawful racial discrimination are harmed. And so again, that is in essence the core harm of what Shelby County has left this country's voting systems with, is the inability to actually prevent these harms to begin with.
Mr. Levitt?
Yeah, so I agree with everything that Mr. McCrary and Ms. Gupta mentioned with respect to the 3C bail-in provision, as it's known. But just one note on the difficulty of complying with the various federal laws on the basis of race. It is true that the Voting Rights Act is relentlessly pragmatic and does not admit shortcuts. But that does not mean that it is impossible to comply with the various constitutional and federal statutory commands. Perhaps this is an LA-based metaphor, but I'm used to driving. And when you drive, it is abundantly true that you cannot ignore the speed at which you're traveling, and you cannot go over the speed limit. But millions of Angelenos, and I think hundreds of millions of Americans, actually drive every day, paying attention to speed without going too far. It is easiest to fail to comply with the Voting Rights Act and with the constitutional commands against excessive and unjustified use of race if you're not trying. And I do not presume bad faith on the part of any legislature going into a redistricting, going into an attempt to comply with the Voting Rights Act or the Constitution. But neither can I turn a blind eye when it has been proven that legislators are acting in bad faith.
Thank you. I understand Commissioner Harriet has questions.
Yes, thank you, Madam Chairman. I guess this question is directed to Mr. Von Spakovsky. He may be the one that would most want to talk about this. I'm not sure we've brought out enough the notion that the Voting Rights Act of 1965 was intended, at least part of it, to be temporary. My understanding of the history of this, I can't quote President Johnson directly here because he had a bit of a foul mouth, so I will instead paraphrase that he wanted a very, 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 very strong act. And he got it. He got it. He definitely did, and it worked extremely well. The efforts to recruit African-American voters in the South prior to the passage of the act, utterly pale compared to what happened in just, a few months after it went into effect. But one of the ways in which he was able to persuade Congress to pass such a strong bill was that it was supposed to be temporary. Can you comment a little bit about the history of that?
Sure, it was intended to be temporary. It was initially for 5 years, and then it kept getting renewed for another 4 times. And
am I right that Katzenbach versus South Carolina is partly premised on the notion that it's constitutional?
Because what Katzenbach said was that the idea that a state, particularly a state legislature, in our federal system and under our Constitution would have to get permission from the federal government before a piece of legislation that it passes can go into effect was an extraordinary intrusion into state sovereignty. It was needed at the time because of what I said, evasion of court remedies that had been ordered in individual suits, and that was certainly needed at the time. But one of the reasons, a key reason that Shelby County occurred the way it was, and I think it's important to remember, is remember the coverage formula was based on having a tester device in place and then registration or turnout of less than 50% in the 1964 election. When they renewed it, they added the 68 and 72 presidential elections, but the coverage formula was never updated after that. What that meant was that in 2006, when they renewed Section 5 without updating the coverage formula, they were basically renewing it based on 45-year-old data. That's as if in 1965, when they passed the Voting Rights Act, they had said, well, we're going to base coverage on registration and turnout in the 1928 Hoover election or the 1932 Roosevelt election. That didn't make any sense to do that. If they were going to renew it, they had to base it on current conditions. And the reason they didn't base it on current conditions in 2006 was because, as the census itself has reported, registration and turnout in the covered states was on parity with, and in some places, black turnout actually exceeded that of white turnout.
Ms. Gupta, I see you wanted to respond.
I would just like to ask the commission to consider the tens of thousands, hundreds of thousands of pages of documents that Congress considered in 2006 that very thoroughly and deeply and comprehensively documented ongoing, serious, systemic racial discrimination in the jurisdictions covered by the Voting Rights Act pre-clearance regime. It's all there publicly, but I think it refutes what Mr. Von Spakovsky said. It was a thoroughly considered bill with a ton of evidence about ongoing real systemic racial discrimination.
Commissioner Yaki, I believe you have questions.
Yes, thank you very much, Madam Chair. First, I find it ironic that we're talking about some of this. When it's said that it was meant to be temporary and Congress nearly in a overwhelmingly bipartisan fashion in 2006 reauthorized this with hundreds of thousands of pages of record, and in which ironically this commission did not, despite my best efforts. It's all we have to do is look at what's going on today and see what the work of Reverend William Barber is doing in North Carolina to know that, that temporary is still today. The question I have goes to the meaning of access. I think a lot of our talk today has been about the impact in terms of redistricting, how that has an impact. But I also want to take a step back because I think one of the pernicious elements of how temporary still is today is the rise of voter ID laws and how they impact the ability to people to access the polls. In the 60s, this commission went down into the Deep South and looked at the literacy and the poll taxes and other qualifications that states put in as barriers for minorities to be able to access the vote. But now, in this century, we've developed new ways of dealing with it. And it's fundamentally built upon a premise that I do not believe, and I would like someone first to ask this. I'm going to ask the person with the most seniority on this. So the most seniority to the most seniority, Mr. McCrary. Part of the premise of these voter ID laws is that there is voter fraud, that there is widespread voter fraud out there in the country. And I would like you, based on your long history with the Voting Rights Act, with your research in Congress, to address that issue straight up.
Commissioner Yaki, there is no evidence of which I'm aware that in-person voter fraud at the polls, the only kind of casting of ballots that is covered by the photo ID requirements of these laws exists anywhere in the United States except in a handful of cases. And I mean literally a handful in most states throughout the millions of votes cast. There is some degree of election fraud in some states where absentee ballot fraud is the area where you can find instances of actual fraudulent behavior by voters. And all of the photo ID laws that I'm familiar with do not apply to absentee ballots.
Right.
They forego absentee ballot reform. Another kind of election fraud that occurs is a kind that involves actions by election officials, party officials. There was one case brought by the Department of Justice in the 21st century, U.S. versus Ike Brown, that dealt with fraud by party officials in Noxubee County, Mississippi. But that didn't involve in-person voter fraud. It involved fraud by the conduct of officials conducting primary elections and in the preparation in the political process for fraudulent behavior, not in-person voter fraud.
So the danger has never been that there's going to be hundreds of thousands or 3 million people impersonating Americans going to the polls or being bussed across state lines to go vote in some other state's primary. That just doesn't happen.
Not in my lifetime, which, as you notice, fairly extensive. It did happen in the 19th century, but we're a long way past that. And therefore, this is essentially a pretext for doing something that has to have other purposes.
Well, I'd like briefly you, Ms. Gupta and Mr. Levitt, to just discuss the mechanics of how these voter ID laws are enacted in a way to deter or turn away or deny voting access for minorities, if you could, briefly.
If I understand your question, you're asking about the litigative process and the evidence in the cases?
Yes.
Well, taking the North Carolina case as an example, the most recent case, there are only a small number of documents that satisfy the requirements of the state law that was challenged in the case, that satisfy its requirements for in-person voting, whether during the early voting process or on election day. Before Shelby County was decided, many more photo ID, documents with photo IDs were permitted to satisfy the requirements of the law. After the Shelby County decision, the legislature removed most of those that were readily available, and the evidence in the case showed readily available to African Americans at a rate far greater than those that were retained in the law. And therefore, the bill was made a great deal more restrictive once the pre-clearance requirements were removed. And that was a part of what the court intended when it rendered its decision, the Fourth Circuit, along with the fact that the law targeted the very reform provisions adopted by North Carolina during the preceding decade, the first decade of the 21st century, that had facilitated the increase in African American participation, which Mr. von Spakovsky correctly notes is very impressive. And once the provisions were identified to the legislators as provisions that had facilitated minority participation, they specifically targeted those and removed, to some degree, removed them from election law.
Mr. Levitt?
Yeah, so this is, I agree with everything that Mr. McCrary said. This issue is one place where I think, as Commissioner Harriet mentioned, there's often a lot of yelling and screaming and comparatively little attention to facts. And so I really welcome when there is factual analysis of all this. Every state has some provision to make sure that people are who they say they are when they come to the polls. Every single state. And so most of the controversy in this area isn't over whether we should have some sort of identification system or some sort of security system. It's about the details. It's about the how. And precisely as Mr. McCrary mentioned, there are some states, relatively few, that have taken steps that are quite restrictive in the documentation they permit. Those restrictions have, it has largely been shown a disparate impact, and in some cases were proven to have been enacted because of that disparate impact. But that's not a condition of having an identification system. It's a condition of the particular choices that particular states have made. So in a circumstance like this, the choices that North Carolina have made are not the same as the choices that Rhode Island has made. The choices that Texas has made are not the same as the choices that Michigan has made. And those distinctions matter. Mr. McCrary spoke to the absence of evidence of widespread in-person fraud, the sort of fraud that these sorts of laws can address. Even though these laws don't do much to take care of a meaningful problem, I think there's relatively little controversy when increased security procedures don't have an impact on real eligible Americans. So if you look at the debate now about whether to secure online registration systems or statewide voter registration databases against hacking, because those sorts of security measures have very little impact on eligible Americans, I think there's widespread bipartisan agreement. Yes, we should do that. The benefits far exceed the costs. The concern is not when these laws are put in place and they don't have impact. The concern is when the laws are put in place based in large part on a pretext that Mr. McCrary has mentioned, with specific provisions that impact people's ability to vote based on their race or ethnicity. There aren't a lot of states in which this is true, but there has been litigation proving that there are some states that have taken this path of extremely restrictive laws in their configuration, in some cases targeting minority electors. And that's, I think, not only the source of the controversy, but where the controversy properly lies. As Reverend Barber mentioned, these sorts of laws that are targeted in this fashion actually, they deprive individuals of the opportunity to have a voice in the election process. And I think that's part of why they are so fiercely contested.
And I just want to apologize that I called you Reverend and you are now a bishop, and I have a bad time with my church elevations. So, but you wanted to just close us out really quickly.
Yeah, I've been called a lot worse.
Bishop Barber, I wanted to say that there are 6 minutes remaining. I know that
Okay.
Commissioner Dagley has a question as well, so we'll try to be speedy.
I just want to mention a couple of things. On this, part of the conversation is that people will say we're not denying the right to vote, but there's another part of the law, it's called abridgment. and photo ID becomes an abridgment. In North Carolina, Democrats and Republicans agreed on signature attestation, and we didn't have any fraud. The very legislators that claimed that there was fraud going on got elected with signature attestation, but never said their own elections were fraudulent. And the fact is, I'm thinking about Rosanelle Eaton, who had been voting for years, who the photo ID law almost undermined her right to vote, and so many others. What we've seen with this so-called photo ID, and it's a red herring to some, because extremists want us to talk about photo ID, and many people that reported on North Carolina said we had a bad photo ID law. No, it was a monster voter suppression law, of which photo ID was only one part. It was the first part that was passed, and then it was held until after Shelby, so that the media was driven by that, and people were not talking about undermining 16 to 17-year-olds in same-day registration and early voting. And we have to speak of it. It's not just one piece; it's the whole.
Mr. McCrary, as somebody who's had 37 years of experience in this space, I think that you can help us understand a key question that's being debated, and that is, are we meaningfully in a different place from 1965? I think that many people would say that we are. But does the fact that there has been progress and that the Voting Rights Act has motivated that progress tell us about whether or not we need to continue to make progress? The idea being that a great deal has changed, but based on your testimony, it seems that in some places there's a great deal that hasn't changed or more that needs to change. Can you reflect on this?
Well, a great deal has changed since 1965 in the South as in the rest of the country. Not all those changes, however, have been linear progression upward. Things have become a great deal more sophisticated in our technology, both in election administration and in the way legislatures operate. There's a great deal more carefulness in the language with which legislators discuss what they're doing, and the procedures, as several panelists have been mentioning, are a good bit more sophisticated than the ham-handed racist behavior of legislators in states where, such as Alabama, where I lived for 10 years. And you don't see that sort of behavior anymore, and you don't see usually you don't see the kind of racial campaign messages that were common in the 1960s, the explicit racial appeals. Now it takes the form of putting your opponent's photo in the newspaper in your own ad to make sure that everyone knows that this is a member of a minority group or something of that sort. In one of the Indian voting rights cases in Montana, we found that another kind of racial campaign appeal was shooting bullet holes in the campaign signs of Indian candidates for election. And so a lot has changed, but if you look at things such as the evidence of racially polarized voting, that is a key part of the empirical evidence in virtually all voting rights cases, even in those involving photo ID requirements or restrictions on early voting and other kinds of access issues. We find that racially polarized voting exists at a degree that is still alarming, though perhaps not quite as alarming as in the 1960s. And in the instance of North Carolina in particular, where there was evidence of increased white crossover voting for minority preferred candidates, that's the very circumstances in which the legislature adopted its discriminatory election law in 2013.
If I could really quickly, despite the fact that things certainly have meaningfully changed since 1965, I want to bear repeating again that since the Shelby County decision, at least 10 courts have found intentional race discrimination in voting. And I think that that is an important thing to mention, given how high the standard is to meet to prove intentional race discrimination. I also want to point out that even 3 justices who were in the majority in the Shelby County decision, Chief Justice Roberts, Justice Kennedy, and Justice Alito, acknowledged in 2006, quote, that racial discrimination and racially polarized voting are not ancient history. Much remains to be done to ensure that citizens of all races have equal opportunity to share and participate in our democratic processes and traditions. So I just, again, against this backdrop or notion that somehow racial discrimination, systemic racial discrimination in voting has ceased to exist. I think that all of this is quite concrete evidence to the contrary, despite the incredibly high bar that litigants have to establish intentional race discrimination. That proof has been met in a number of instances, and even three justices on the majority of Shelby County acknowledge its continued existence.
Mr. Levitt, can you explain to us very quickly the nature of voting discrimination? That is to say, lots of time when you have a discrimination case, there is something that's visited upon a particular individual and there's a case brought. Occasionally they're broader class action cases. But I'm interested to understand, because of the nature of voting rules, the ripple effects and the reach of discrimination when you have official actors, whether it be at a local level or a statewide level, passing discriminatory laws. Can you explain that to us and tell us what you think it means that there are many statewide legislatures that are being found to have repeatedly, in the modern day, intentionally discriminated against minority voters?
The voting cases and the discriminatory voting cases are essentially about clinging to power. And when cases are brought and succeed under the Voting Rights Act, they show clinging to power in some of the most pernicious ways possible against a class of people attempting to diminish either their ability to cast votes or the impact of those votes across an entire political structure. That undermines all of the rest of the bases for law that we have, that undermines legislation later passed on any number of social or economic issues that we find important. Sometimes that discrimination looks, sad to say, much as it did in sort of the bad old days, based on explicit animus. More often, the animus is subtextual or otherwise hidden. And even more often, the discrimination may not be based on animus, but is instead based on perceived partisan gain. Nevertheless, using individuals' race or ethnicity as a proxy for achieving that partisan gain. And I want to make perfectly clear that all sorts of that discrimination are pernicious. It is not an excuse for intentionally discriminating on the basis of race that really broader political goals were the underlying motive. It is just as problematic to take steps against a class of people based on their race or ethnicity, no matter what the underlying motive would be. And sadly, I think we see the "it's just politics" excuse being proffered more often and given more credence than it should in the States.
We are unfortunately out of time. This is an animated panel. I very much appreciate your sharing your expertise with us. We will take a break now until 10:50. It's a reminder that the registration is now open for the first half of the public comment section, and we will commence the second panel at 10:50. Thank you very much.
I thought she said 10:15. I need to hear you. No, it was in the building. I mean, this is serious. I'm on the bridge. Like, no one
We are past 10:50. It is time for us to get started again. I'm going to ask folks to come back up. Have your seats. We're coming back to order. It is now 10:52. We're proceeding with the second panel. In the order in which they will speak, our panelists are Ezra Rosenberg, co-director of the Voting Rights Project at the Lawyers Committee for Civil Rights under Law; Nina Perales, vice president of litigation at the Mexican American Legal Defense and Educational Fund; J. Christian Adams, general counsel at the Public Interest Legal Foundation; Dan Marinoff, executive director of the Equal Voting Rights Institute; Natalie Landreth, senior staff attorney at the Native American Rights Fund and chair of the Commission's Alaska State Advisory Committee. Thank you for your service to the Commission. Sherilyn Eiffel, president and director counsel at the NAACP Legal Defense and Educational Fund. Mr. Rosenberg, please begin.
Thank you, and I'd like to thank the Commission for holding these important hearings, and particularly for holding them in the great state of North Carolina, which has been particularly hard hit by suppressive voter laws over the past years, as we just heard. The Lawyers Committee for Civil Rights under Law has been at the forefront of the fight for equal justice, and particularly for voting rights and equality and voting rights for African American populations and other racial minorities since 1963, when President Kennedy convened a meeting of the leaders of the private bar and implored them to start lending their services to fight for equal rights. And by way of aside, until 3 years ago, I was one of those private practitioners, and I'm humbled to be here today and to be on a panel with true experts. That more than 50 years later, we are still concerned with the issue of equal rights in voting is sad. That we are more concerned about it than we were 5 years ago is incredible. We are clearly not in the place that we expected to be. When in 2006, just 11 years ago, a unanimous Senate and a nearly unanimous House of Representatives reauthorized Section 5 of the Voting Rights Act. That bipartisan dream came to a thudding crash with the issuance of the opinion in Shelby, which gutted Section 5, which gutted the Voting Rights Act, and the words of Congressman John Lewis, struck a dagger through the heart of the Voting Rights Act. The laws of protections afforded by the preclearance provisions of Section 5 have a certain nuanced aspect, and that is a lack of notice now that we have that discriminatory practices are about to go into effect. We can only fight that which we know about. And too often, there are discriminatory practices that take root and bear fruit before they can be stopped. We've seen many forms in which these sorts of practices take. They range from the consolidation of polling places, which make it more difficult for minorities to vote, to the curtailment of early voting, which makes it more difficult for hourly wage workers to vote, to the purging of minority voters from voting lists under the pretext of list maintenance. Georgia, a state previously covered by Section 5, provides an example of some of these practices. In 2015, the Hancock County Board of Elections started a challenge process, which resulted in the purge of 53 voters, all but 2 who were African American. We were able to stop that practice through litigation. We were able to reinstate some of those who had been wrongfully purged, but by then the damage had been done. Sparta, a small, predominantly Black town in Hancock County, had elected its first white mayor in 40 years. Also in 2015, the Georgia legislature undertook a pinpoint redistricting of 2 legislative districts, which, because of growing minority population, had become increasingly competitive. And they moved in some white voters and they moved out some Black voters. We've sued on the basis of a racial gerrymander. That suit is pending, but an election has already been held in those districts. In Macon-Bibb counties, the Board of Elections in 2016 decided to temporarily relocate the polling place from a Black neighborhood to the local sheriff's office. There, we got notice ahead of time through our local partners. We were able to help mount a petition drive and change that decision. However, placing the burden on small local groups with strained resources to keep a wary eye out for these subtle sort of changes places an enormous burden on these organizations. And until Shelby, and before Shelby and after Shelby, we did have a partner in the Department of Justice, a partner with greater resources in the civil rights organizations. But in the past year, the Department of Justice Division of Civil Rights has not filed a single action under Section 2 of the Voting Rights Act. We in the Lawyers Committee with far fewer resources have 2 such actions filed under Section 2 and another racial gerrymander claim, in addition to another 8 or 9 Section 2 cases already on our docket. In 2 of those cases, one filed in 2016 and one in 2017, we were able to achieve quick results. The establishment of majority-minority districts in Jones County, North Carolina, and in Emmanuel County, Georgia, which speak to the fact that energetic enforcement of the Voting Rights Act can lead to immediate relief for minority populations. The previous panel talked about the change of positions in the Texas voter ID case, which I have been litigating now for 5 years, and in the Ohio purge case by the Department of Justice, away from positions favoring minority rights that the department had taken until months before. Those reversals of position can be perceived as a wink of the eye to those jurisdictions that wish to push the envelope towards discriminatory practices, and a cold shoulder to those vulnerable populations who have for a long time relied on the Department of Justice to have their backs. The single most proactive step taken by the federal government over the past year in the voting rights arena has been the creation of the Presidential Advisory Commission on Election Integrity. Now, while litigation by the Lawyers Committee and other civil rights organizations may have speeded up the demise of that commission, there still is a threat of using this canard of the myth of voter fraud to further suppressive voter legislation, as evidenced by the tweets by the president, commensurate with his dissolving of the commission, that elections in this country are rigged, and therefore there should be strict voter ID laws. The combination of the gutting of Section 5, the increasing inactivity of the Department of Justice, and the joining of forces with those who purvey the myth of voter fraud creates a perfect storm not seen since the days before the 1965 Voting Rights Act. We urge the Commission to do all it can to vigorously help enforce those laws and protect the right to vote. Thank you.
Thank you, Mr. Rosenberg. Ms. Perales?
Very good. Thank you all for having me. My name is Christian Adams.
I'm sorry, Ms. Perales, did you not want to go?
No, I did. I just thought that Mr. Adams wanted to go before me, but
I didn't.
Ms. Perales, you are next in line. It is your turn.
That's what I thought too, just to be clear. Okay.
Please turn your microphone on. Thank you.
I'd like to thank the chair and the members of the commission for inviting me to testify here today. To get right to it, the impact of the Shelby decision has been negative, and its effects on minority voters have been twofold, at least within the scope of my experience. First, retrogressive practices that formerly would have been blocked through the preclearance process are being adopted, and they are going into effect. Second, the burden to halt these practices has shifted over to minority communities, which now have the burden and the responsibility of trying to gather the resources that they need to end these practices. The lens through which I'd like to discuss these observations is MALDEF's successful legal challenge to a post-Shelby change in method of election in the city of Pasadena, Texas. Pasadena is not a huge city, not a small city, about 150,000 people in Harris County outside of the city of Houston. Pasadena is the former state headquarters of the KKK, And a number of our witnesses who've lived in Pasadena for many years recall driving through town as children or even as young adults and seeing members of the KKK in their robes standing at major intersections handing out their literature. And that was what it was like to be Latino or African American as a young person in Pasadena. I'd like to make a small and respectful correction to Mr. Von Spakovsky. Pasadena was covered by Section 5's preclearance provisions from 1975 until 2013. 3 weeks after the Shelby decision, in July of 2013, the mayor of Pasadena announced a plan, an important new idea that he had to change the method of electing members of the city council. At the time, Pasadena had 8 members of its city council who voted, and the mayor would cast a vote if there was a tie among the 8 members. And what had happened in Pasadena was that the Latino community had grown over the years. And at the point at which the mayor announced his plan to change the method of election, the council vote was often tied between 4 members of the council who were either Latino themselves or were being elected by substantially Latino single-member districts, and 4 members of the council who were coming from primarily Anglo areas of town. Pasadena had converted to single-member districts sometime in the 1990s, and there was this moment of pressure as Latinos came up and became the population majority and then started to exercise more political power on the city council. Some of the issues that Latinos were interested in, some of these votes that began to break 4-4 on the city council, included questions of resource distribution. Drainage and the quality of streets was very poor in the north part of Pasadena, where most of the Latino community lived. There were also some financial dealings of the city that Latino voters were very unhappy about, and they wanted more transparency and greater distribution of resources towards their neighborhoods and their community. As a result, the mayor found himself casting more and more tie-breaking votes on what had become a split council. And so he proposed, and the city electorate adopted in an at-large election, a conversion of 2 of the seats on the council to an at-large, so that the system shifted from 8 single-member districts to a 6-2 mixed system. Shifting these seats from single-member districts to at-large voting solidified Anglo control over the council, even as the city became majority Latino in total population. At the time, Mayor Isbell pointed out, quote, "The Department of Justice can no longer tell us what to do," unquote. And he was absolutely right, because it was 3 weeks after the Shelby decision, and the Justice Department was no longer going to tell Pasadena how it could run its election system. Even though in the past, other cities in that region of Texas had had attempts blocked by the Department of Justice to change at least some of their seats from single-member district to at-large voting. Malda filed suit in 2014, and I want to just touch for a moment on the details of how incredibly time-consuming and expensive this litigation was. We took or defended 35 depositions in the case. Between the plaintiffs and defendants, we had 7 expert witnesses. Expert witnesses are not cheap. We did extensive paper discovery because in order to prove the Senate factors, you don't just need a historian. You need somebody to talk about present-day events in the city. And so there were many thousands of pages of documents that we requested and received from the city that helped us build an explanation around what had happened recently in Pasadena. And then finally, for a 2-week trial, we had to relocate our entire trial team to Houston, where we do not have an office, and try the case in November and December of 2016. In January of 2017, the federal court ruled that Pasadena had intentionally discriminated against Latino voters and that the change was also dilutive of Latino voting strength. Pasadena appealed, and it was another 9 months before we were finally able to settle this controversy. All in all, it took approximately $3.5 million and 3 years to resolve what could and should have been resolved through the pre-clearance process. Thank you.
Thank you, Ms. Perales. Mr. Adams?
Thank you very much, Madam Chairman. My name is Christian Adams. I served for 5 years in the Justice Department in the voting section and brought a variety of cases under the Voting Rights Act as well as Section 5 reviews before Shelby, including congressional redistricting. One of the most effective ways to preserve the viability of the civil rights laws, I believe, is to remove partisan interest from civil rights law enforcement. Previous panel touched on this issue a bit when it indicated that partisanship can sometimes provide an inadequate, if you will, defense to a claim under the Voting Rights Act alleging intent. But bear in mind that partisanship is indeed a defense to a Voting Rights Act claim, and I think whatever work this commission sets out on doing should be keenly aware of the dangers of partisanship in Voting Rights Act enforcement. The Voting Rights Act has enjoyed broad bipartisan support for decades, but if enforcement of the law is hijacked by partisan interest, it will lose bipartisan support. Now, some would be happy to travel the dangerous road of turning the Voting Rights Act into a partisan weapon. Some are even brazen and open about their goal of doing so. A few years ago, for example, there was a law review written by University of Michigan law professor Katz, who called for just such an outcome. It was titled, quote, "Democrats at DOJ, Why Partisan Use of the Voting Rights Act Might Not Be So Bad After All," and it was published in the Stanford Law Review, Law and Policy Review. To this end, reasonable state election laws have been challenged under the Voting Rights Act in a concerted effort by lawyers representing partisan interests. Right now, for example, there is a challenge to the very existence of recall elections in the state of Nevada using the Voting Rights Act. The case makes what I believe to be the immoral and frankly bigoted claim that minority voters are less capable of voting in a recall election because they don't pay close enough attention to the public issues and might have to vote twice. That is the theory of the case. My organization is a defendant intervener in the case on the side of Nevada, defending the state recall election against this partisan use of Section 2 of the Voting Rights Act. If the theory in the Nevada lawsuit is the future of the Voting Rights Act, the enforcement of this important law will eventually enjoy dwindling support among only a small fringe far outside of the mainstream. Predicating enforcement of the law on the idea that racial groups aren't smart enough to pay attention or are otherwise less sophisticated, as experts for the Justice Department in some of the litigation discussed today testified, it not only offends the dignity of those individuals, it is well outside the jurisprudence of the Voting Rights Act. My view is that such nakedly partisan use of the law will eventually erode support among the general public for the law. Now, we heard a lot of testimony about Shelby and its effects. And I will tell you that I brought one of the last cases of the Justice Department to challenge at-large elections against the city of Lake Park, Florida. And that was in almost a decade ago. Since Shelby, there hasn't been much activity, as we heard from the last panel. A more recent DOJ case filed against East Point, Michigan, late in 2016, appears to have a number of significant defects where the defendants savvy enough to press those defenses, which so far they have not. Simply, the Department of Justice, with its vast arsenal of resources, hardly brought any cases for violations of the Voting Rights Act after 2009 and after Shelby. The numbers cannot be ignored. What is most striking about the post-Shelby world is how little difference the decision seems to have made to actual voting. It is easier to register and vote now in the United States than it ever has been in the history of the country. Nothing about Shelby affected that undeniable fact. Lawyers have struggled to find actual plaintiffs who face insurmountable obstacles in voting. One famous incident in Philadelphia, a plaintiff challenging state voter ID laws claimed she could not acquire acceptable identification to register to vote. When a lower court threw out her case, she quickly visited a PennDOT office and received her ID the same day before her lawyers could stop her from doing so and mooting her appeal. This is the sort of farce that accompanies some of the recent challenges to state election law. States were given the power to run their own elections in our Constitution. Naturally, they must do so in conformity with the various amendments to the Constitution and statutes affecting elections. The presumption that states may manage their own elections is not some accidental choice. It was a choice informed by the lessons of history that centralized federal control is eventually adverse to individual freedom. The founders knew that a central authority with control over state elections would invariably erode liberty. As the Supreme Court put it in Shelby, the federal balance is not just an end in itself. Rather, federalism secures to citizens the liberties that derive from the diffusion of sovereign power. I would urge this commission to look carefully at the abuses that occurred in enforcement of Section 5 in the past. Johnson v. Miller, of course, is the most famous one. The butcher's bill for that case ran into the tens and frankly hundreds of thousands of dollars for the abuses of Section 5 abuse. What should Congress do to stop those abuses in the future? Should it make individual DOJ employees liable? Should it do something else? But the abuses aren't just public. I remember when I was at the Justice Department that many times organizations and local leaders were opposed to a submitted change. Yet, sometimes individuals carry an inordinate amount of clout in a Section 5 review process, and we were often instructed to call Representative Tyrone Brooks of Georgia to ask him what he thought about a submission. Because even if a lot of people oppose a submission, Mr. Brooks had the power to get something pre-cleared. Now, that's something that isn't in the public record, but that's something that is a fact. That people had inordinate power behind closed doors to have things approved or rejected, not based on the law and the facts, but on their clout to get something objected to or pre-cleared. And that's something that the commission, if it does a report, has to make a recommendation to remedy. Thank you very much for your time.
Thank you very much, Mr. Adams. Mr. Morna.
Thank you. Let me first just start by thanking y'all for including me on this panel and in this event. I am well aware that my organization is the youngest of the civil rights organizations that you've included, and we really appreciate you giving us the opportunity to come here and speak. And to be clear, we sue governments. That's what we do. We absolutely recognize the harms that members of the last panel spoke to that arise from the usage of Section 2 rather than a no longer available Section 5. It is certainly true that illegal elections happen while litigation is pending. We've got a case pending right now. We've been pending for more than 3 years. So those things are facts and they are material. You've asked us to discuss on this panel a series of questions, several of which I have literally no ability to address at all. I have never worked at the Department of Justice. I cannot address the 3 issues you asked us to about how DOJ's enforcement decisions have been affected by Shelby. I do want to address the other 4, 2 of which are about the Shelby decision itself, with an eye towards what it means for what could be in a new update of the Voting Rights Act, as well as the 2 additional issues that you've given us as to the impact of Shelby more broadly. To begin with, the first of the about the decision side issues, you'd asked us to discuss the Shelby majority's rejection of the congressional record, and specifically what it would mean Congress would need to do to have a new act survive judicial scrutiny. There are really two ways that the court rejected the record, one of which has already been addressed, and I don't think the other has. The first was that the court held that while the record certainly documented the existence of ongoing discrimination, it did not believe the record to reflect the kind of concentration of discrimination that on the pervasive scale that it existed in the Jim Crow South and been the reason for the creation of Section 5 and the Section 4
coverage formula in the first instance. And they cited various things, including, I believe, the fact that Section 2 litigation in the years between 1982 and the Shelby decision had reflected almost twice as many cases of intentional discrimination in uncovered jurisdictions as in covered jurisdictions, as well as a number of things that I think Mr. Van Spakovsky addressed. The second one, of course, was that according to the court, regardless of what was in those thousands of pages compiled by Congress, the Congress simply didn't use that record. This was what Ms. Gupta referred to when she mentioned that if there is to be an update reimposing preclearance, it's simply going to have to be based on current statistics. I think that's pretty clear. I don't think anyone argues that that's what the court is requiring. I do want to jump back to that first factor, though, to what was actually in the record and how the court invalidated. Because while they used the language of state sovereignty, and in particular, the federalism costs of preclearance, I don't read this as actually being a 10th Amendment concern. I don't think that's what the court is talking about. I don't think it can be talking about that, given that in this very opinion, it agreed that Congress has the power to intervene in the way that it did in creating preclearance to begin with. Instead, I would suggest that this is best read as as the court rediscovering the systematic preference for laws of general applicability. This is really an equal protection concern. If there are minorities in this state which have preclearance protecting them, and there are minorities here who don't, they are not equally protected. Their rights are not equally protected by the congressional act. And I think that we should really read the court's opinion here as an instruction that that if Congress is going to reimpose preclearance, it should do so equally for the nation as a whole. Write a law that applies everywhere, not just in the jurisdictions you don't like. The minority, on the other hand, Justice Ginsburg wrote in part finding that Section 2 cases are more likely to be successful in what had been covered jurisdictions than in uncovered jurisdictions. That's a fact. It's true. Mr. McCreary rightly observed this. He observed it with the note that preclearance is the solution because there are things that otherwise won't be caught. That there's a real problem with using the Section 2 data point when we don't know what's going on. There is a second problem here, which is the circularity of the reasoning, given that in any Section 2 case, at the totality of the circumstances analysis that courts engage in, one of the things they look for is there a history of discrimination? Given that we know that the preclearance formula was created to put into covered jurisdictions those places that had a history of discrimination, we should expect that that factor is going to lead to a greater level of success in litigation against those covered jurisdictions. That isn't actually indicative that there is greater discrimination there than elsewhere. It's just a result of how the courts have chosen to measure this. So again, I would suggest that it's necessary for the Congress to avoid circularity. You've got in my materials the actual chart of filings under the voting rights jurisdiction of the courts. It is perfectly clear that there are simply less cases filed this decade than last. It is equally clear that there has been a mid-decade surge in filings, which are definitionally after Shelby. That was true in the previous decade as well, though in this decade there have been more of them and they've accelerated more quickly. I'll also simply point out that if going from 2000 to the present, at no point in that period has DOJ actually filed a material percentage of the voting rights cases that were filed. The laboring war has always been handled by private organizations, and it still is. Thank you.
Ms. Landra. Thank you very much, and good morning to the commissioners and chair. I want to thank you very much for inviting me to speak here today. Often when civil rights issues are discussed, the Native American perspective is not included, so I appreciate the real attention to this issue. There's a great deal of activity going on in Indian country related to voting rights. So my name is Natalie Landreth. I'm the senior staff attorney at the Native American Rights Fund. I am based out of the Anchorage office, but I work on voting rights issues nationwide. I am also chair of the Alaska State Advisory Committee. Today, however, I am testifying solely in my capacity as a litigator of voting rights cases at the Native American Rights Fund. And I can only describe my job right now as trying to empty the ocean with a teacup. That's how bad it is. You just heard Mr. Mornoff describe how the burden is often borne by private organizations like mine. And I'd like to explain how big that burden is now that Section 5 is gone. The first thing I'd like to point out is, of course, there's been some discussion about the imprecision of the coverage formula in the Shelby case, and one of the examples I often heard during the pendency of the case. And of course, mentioned in the Court of Appeals opinion was that one of the examples, oh, Alaska's covered, this formula must be wrong. And let me tell you something, anybody who thinks Alaska was covered by mistake doesn't know anything about Alaska. During the pendency of the case, they had just lost a Section 203 and 208 case, and a second one had just begun. And yet people were saying to the court, this is an example of how imprecise this formula was. Alaska was covered statewide, and statewide for good reason, because it was the last state to have a literacy test. 1970-71 was the legislative session in which it was abolished. And it had never fully implemented Section 203 ever. When I walked into the courtroom in 2008 to do an oral argument on the Voting Rights Act and its implementation in Alaska, it had been active and covered for 35 years. And the state at that time had 2 pieces of evidence that they could provide that they had ever translated any voting materials. And they were 2 30-second ads. So I asked the court to sit through those. And I said, that's it. That's all there is for 35 years. I think it's clear enough that Alaska was correctly covered and correctly captured in the formula. We sued based on widespread 203 and 208 violations, as I mentioned, but I want to add as well, as Ms. Perales pointed out, the enormous burden that it places on private organizations. We spent over $200,000 in expert costs, over $1 million in legal fees, conducted or defended 25 depositions, had 30,000 pages of discovery, and unfortunately for our district court judge, a staggering 720 docket entries, which is a filing basically every 3 days for the entire case. That is the heels that were dug in by the state at that time. I'd like to point out that at no time did the Department of Justice intervene and assist at all. In fact, in Indian country, the DOJ has not brought a case on behalf of Native Americans in almost 20 years. The last one was South Dakota in 2000, and before that was Blaine County in 1999. Their involvement has been limited to filing amicus briefs or statements of interest. Though important, it doesn't compare to the impact of them bringing their own case. And I'd like to point out that the entirety of the litigating lawyers in Indian country are almost in this room. Mr. Rosenberg, Ms. Arusha Gordon at Lawyers Committee, Mr. Ho at the ACLU Voting Rights Project, myself, Lachlan McDonald, Brian Sells, and Jim Tucker. That's it. Those are all the people defending the rights of over 500 tribes in the United States. The DOJ did assign, during this time, federal observers to Alaska, and that has been one of the most important decisions because it is the only way that we can now find out what's going on in the polling places. And that's another part about the loss of Section 5 that people don't often talk about, is now they do not have the ability to assign observers. And so when we settled our second consecutive Section 203 case, after, of course, winning a victory, we settled the remaining claim, we were required to include in that settlement that the state agreed to federal observers because it was the only way we could keep them. And now it's the only way we know what's going on. In that case, the Department of Justice filed a statement of interest. It was very important to them articulating the law. I want to point out as well that at that time, we realized the pervasive nature of a lot of the voting rights problems in Indian country. So we created something with Lawyers Committee, ACLU, and other organizations called the Native American Voting Rights Coalition, just to manage these issues together. We've done 2 major projects. One is to conduct a survey, and the second is to conduct some field hearings to find out exactly what's going on in Indian country. And I want to point out the first and ever largest survey as a coalition. NARF can't take credit for it on its own. There are 2 things that I'd like to point out. It's over 122 pages of findings. It was a 30-minute survey conducted across 4 states. Number 1, almost 1/3 of eligible American Indian citizens are not registered to vote. They don't have access to registration. It's not so easy. In a lot of these places, they told us it was 89 miles one way to go to the nearest registration, or that in Nevada, you had to have a number with a form with a specific number on it, and they count each form. Second thing I'd like to point out is that although the number of varies by state, only 22 to 26% trust voting by mail. It's not a panacea in Indian country, and we really wish people would stop advocating for vote by mail as some sort of massive solution. They won't do it because they have to share PO boxes, and often the reservations are not platted and they don't have street addresses and cannot receive their absentee ballots in the same way. Finally, I'd like to mention just some of the indications of what we found out in some of our field hearings about just how bad the situation is in Indian country, and to keep in mind that most of the people that will have to litigate these are in this room. Voters in one case were told at a field hearing that they had to go retrieve their ID from home, even though the law allowed the use of an affidavit, and of course, almost none of them returned. One reservation comprises almost 90% of the county, but it has no polling place, and instead it was moved to an all-white community with only 14 residents. Tribes are told sometimes, especially in the Dakotas, if they would like polling places on their reservations, that they get to pay for them. I'd like to see you tell that to someone in another community. They can vote if they can pay for their polling place. And finally, one of the most egregious examples we found was voters who asked for years for a place to vote and were told they could have the chicken coop. That is the state of the voting rights today, and without the protections, we find ourselves on the front line defending them after they've occurred. Thank you.
Thank you, Ms. Landra. Ms. Eichel?
Good morning. My name is Sherilyn Eiffel. I'm the President and Director Counsel of the NAACP Legal Defense Fund, the organization founded by Thurgood Marshall. And I'm very grateful to you not only for inviting me to participate in this hearing, but for convening this hearing at all at this moment in our country. I think it's critically important, and that's why I wanted to be here today. This year marks the 150th anniversary of the 14th Amendment, the amendment to the Constitution that by its explicit terms was designed to give full citizenship to African Americans who had been formerly enslaved. Our civil rights statutes, including the Voting Rights Act, derive from those Civil War amendments that were designed to affect the dignity, the personhood, and the citizenship of African Americans in this country. The importance of our civil rights statutes, including the Voting Rights Act, is an acknowledgement that the problem of racism and power and democracy in this country reflects structural impediments in our country. They're not issues of personality, they're not issues of individual action, but actions of structure in our constitutional framework. And that's important because in this moment in this country, so much of our focus on race and injustice happens in the context of personality and of spectacle. And this hearing provides us with an opportunity to return to the fact that the framers of the 14th Amendment, the framers of our civil rights statutes enacted in the late 1950s and through the 1960s, recognized that we need structural solutions to the structural problems in our country. It's important to me also because I think this is a key democratic moment in our country as we deal with this issue of voting rights, and particularly of voting rights in the post-Shelby world. Over the last year, we've seen some of the most egregious, odious, and distressing presentations of white supremacy and racism in this country. We've seen young people marching in the streets with Nazi flags. We've seen violence. We've even seen murder. And we recognize that as white supremacy. We recognize that as something that comes against our very national soul and the core of our democracy. But I'd like to posit to you today that when legislatures in our country meet, as they did in Texas and as they did in North Carolina, and they pass laws that have been found by federal courts to have the express purpose and intent of discriminating against African Americans and Latinos and keeping them from participating fully in the political process and exercising their rights as citizens, that too is white supremacy. That too is odious. That too is a blow to our national soul and to our democracy. And so it's vitally important that we stare this in the face and that we recognize that we continue to have this ongoing problem in our country that the framers of the Voting Rights Act recognized when they enacted Section 5, They created the preclearance formula precisely because they recognized that racism was longstanding and was likely to extend into the future. They created Section 5 to get at what they called the ingenious methods of voter discrimination that they couldn't imagine in 1965. They looked into the future and they wanted to create a mechanism that would allow us to get at future discrimination, and they did so. And what they believed has come to pass is most certainly as true today as it was prior to the Shelby decision. We reference in our testimony, and you can go to LDF's website to find our publication, Democracy Diminished, that sets forth all of the discriminatory voting changes that have been put into place since the Shelby County decision, changes that could not have happened prior to that decision. I want to speak very briefly with the time I have left about our challenge to Texas's voter ID law. Once again, this is a law that could not have been enacted but for the Shelby decision. And in fact, it was a law that the state had attempted to enact, and it had been thwarted from doing so because of Section 5 prior to the Shelby decision. And we saw this all over the covered jurisdictions, laws that had lain in limbo because of Section 5, like Alabama's voter ID law, were suddenly enacted after the Shelby decision. The Texas voter ID law was regarded as the most stringent voter ID law in the country. It is a law that specifically identified forms of ID that it was less likely that African Americans and Latinos would possess, and made those ineligible to support voting. But forms of ID, like a concealed gun carry permit, were allowed to be used as identification for voting. When I describe the discriminatory nature of this voter ID law, like the discriminatory nature of the omnibus voting rights bill enacted in North Carolina, I'm not speaking simply as an advocate. I am describing what was found by a federal court and upheld by federal courts of appeals. And I think this is important because in the moment that we're in, a moment in which there is even such a phrase as alternative facts, this panel is important because litigation does something unlike rhetoric, unlike arguments, and unlike debates. When we file a complaint, we set forth allegations of what we believe to be true. Those of us who've been to law school know they're not facts yet, they're allegations. They go through the crucible of litigation. They go through discovery. They are tested. They go through a trial. There are witnesses. There's cross-examination. There's rigorous review by a judge who can assess the credibility of witnesses and review the documents and understand the legal questions. And when that judge issues a decision, that judge issues something called findings of fact. And those things that the judge finds in that opinion are now true. They are accepted as facts. And that means that the North Carolina omnibus bill, the Texas voter ID law, have been found by federal courts, upheld on appeal, to be racially discriminatory. This is evidence that the Supreme Court simply got it wrong. And Congress, the bipartisan Congress that reauthorized Section 5 of the Voting Rights Act in 2006, should be outraged that the Supreme Court countermanded their assessment of what was necessary in the legislation, and that what they believed was necessary has been borne out to be true by federal courts in multiple states. So what do we do at this moment? At this moment, we have to recognize that we have a democracy problem. We have a problem of intentional discrimination. We have a problem of discriminatory effects. It can be resolved, but Congress must have the will to do its job and protect the voting rights of African American, Latino, Asian American, Native American citizens in this country.
Thank you, Ms. Eiffel. Thank you. Commissioner Arasaki?
Thank you, Madam Chair. I have a couple of questions for a couple of witnesses. I'm going to ask you to keep your responses brief so I could get to all of them. I wanted to start with Ms. Perales. There's been a lot of discussion about the scope of the Shelby decision and whether Section 5 should have continued to work in the way it was. I know that MALDEF has thought a lot about what it would like to see to replace Section 5 should Congress revisit it. Could you explain some of the things that MALDEF is proposing in terms of how you would instead trigger Section 5?
Please turn on your microphone. Thank you.
Thank you. Because I don't work in our DC office, I cannot give you the exact details of each and every of the legislative proposals that we have commented on. What I can say is that the heart of the preclearance mechanism is something that's vitally important for us to preserve, and that in the areas where we do litigation, where there is substantial Latino population throughout the Southwest, whether it's Arizona, California, or Texas, we do need coverage because the community and the few lawyers who are there to serve the community cannot keep up with what happens today.
Thank you. Let me move to Ms. Landreth. So one of the focuses that you have had has been the compliance with Section 203, and you mentioned that the Department of Justice has not actually been that active in the past in enforcing Section 203. What are the tools that they have? What should they be using? Are they doing anything that's effective? And what recommendations would you make to DOJ and to Congress to better enforce and improve language access?
Thank you, Commissioner Narasaki. I think one of the things that I'm not sure has been discussed this morning that people really need to understand was exactly how Section 5 worked. It worked through what are called MIRs. It worked through more information requests. It did not work through successful lawsuits. And here's how it happened. In 2008, I believe that's the correct year, very recent, the state of Alaska proposed a project called Precinct Realignment, which was combining precincts that are separated by air so that you would have to fly to vote in a neighboring village. We immediately objected and explained to the Department of Justice when they called these lists of contact people. I was one of them. I got calls all the time, and I was grateful for it because the people on the other end of the line had no idea these communities were not connected by road. And so I said, absolutely, this is inappropriate. And what they did was they sent a letter called a more information request. And what we can see, if those are tracked, is that after the MIR letter is sent, the proposal is removed. And so it doesn't get to an objection. It doesn't get to a lawsuit because that's how Section 5 worked. And people did not look closely enough at the role of MIRs because what the DOJ did was prophylactic on the front end. And a lot of the things that you see described here today are things that would have been caught in that process. Second part of your question was what they can do to, to enforce correctly the Section 203 of the Act. I think an under-enforced portion of that Act, the number of covered jurisdictions for Section 203 changed somewhat in the last listing, which I believe was in December of 2016. Great attention needs to be paid to that. In the two cases that we've litigated, the standard has been set out in a very clear way that the ratio is 1-to-1. If you provide a voting material in English in a covered jurisdiction, it also has to be provided in the covered language. One and done. Simple. This law needs to be enforced more frequently because I see voting materials all over the country in various Indian languages that are one piece versus an entire 100-page booklet, one piece of information in the covered language.
Thank you. And I'd like to ask Mr. Rosenberg and Ms. Eiffel the same question I asked Ms. Perales. So what would you be recommending for a revitalized Section 5?
Well, I think the important thing right now is for there to be a discussion in Congress on this. There are two bills I understand are pending, or at least have been drafted, one of which is bipartisan, actually. And I think it's important for there to be this sort of discussion that looks at what you've heard here over the past hour and a half, that there are substantial instances of the continuation of racial discrimination in voting, of the precise sort that set the stage for the original Voting Rights Act. So I think the important thing right now is for there to be a debate on this, an open debate, and hopefully a bipartisan response. The Lawyers Committee has not taken a position, as I understand it, on either of the bills that are pending yet, so I don't want to take an official position today, but I think the important thing is for there to be a move on the legislation.
Thank you. My answer is largely the same. There are several proposals that have been knocking around for a number of years. It's been alarming that we have not even been able to get a hearing on a bill to talk about what we think would be necessary. I think many agree that the formula will apply nationwide. The likelihood that a number of the states that were formerly covered by preclearance will be captured in that formula is likely true. But it's true because the formula would be based on the actual discrimination and voting discrimination in those jurisdictions. We've already heard this morning about some of the cases that have involved findings of intentional discrimination. There are other cases that have found violations of the Voting Rights Act. And so some menu that looks to those violations would be the one that would trigger states being covered by preclearance. I do want to suggest that what I think is most important, and I think what you're hearing uniformly, is the need of some sense of urgency about this. If you think about one case alone, Ms. Perales referred to a case that she litigated for 3 years, and Ms. Landreth also referred to the length of time and the volume of litigation that they've been engaged in. The Texas voter ID case is a case we filed in 2014. We received a judgment from the district court judge that the voter ID law was discriminatory in 2014. It is now 2018, and we are still litigating that case. We have been, the decision was affirmed by the panel on the Court of Appeals. It was affirmed in bank. We went back to the district court on the question of intent. We had the Justice Department drop out and switch sides on intent. We just had another oral argument before the district court judge in December. This is a case that's been going on since 2014. And lest we think this is just about litigators, let's talk about the offices that have been up for election since 2014 under this discriminatory voter ID law. In 2014 in Texas, voters voted for a U.S. Senator, all 36 members of Congress, governor, lieutenant governor, attorney general, comptroller, commissioners, 4 justices of the Texas Supreme Court. In 2015, there was a special election for a member of the state Senate. In 2016, the presidential primary, 36 members of Congress, 3 Supreme Court justices, state boards of education, 16 state senators, all 150 members of the state House, over 175 district judges, over 75 district attorneys. These are all the offices that have been up for election and in which voters in Texas have voted under a scheme that was found by a federal court to be intentionally discriminatory. That's a stain on our democracy. That is unfair to the voters and the citizens of the state of Texas. And so whatever is going to be the formula, what is most alarming is the lack of urgency that we see from this Congress. Another reason why this hearing is so important, that this Congress doesn't think it's important that over 600,000 people who we found did not have the voter ID to be able to vote in Texas, could not participate in all of the elections I just described to you since 2014, and that's not regarded as a democratic crisis, as a problem. So the urgency, I think, is the piece that has to be conveyed, and it has to be conveyed not as a matter of partisan politics, but let's remember the overwhelmingly bipartisan reauthorization of the Voting Rights Act in 2006, but as a matter of democratic principle and constitutional integrity.
Commissioner Hurd? Commissioner Yaki? Commissioner Dugway?
Ms. Perales, can you describe to us some of the lessons that came out of the LULAC redistricting decision and how the Supreme Court made some observations about the nature of voting discrimination visited upon Latino voters in Texas? And in particular, I'm interested in a potential theme that I see between that case and the case that you just described in Pasadena. This notion that when minority voters are on the precipice of exercising their voice in the political fora, that discrimination is visited upon them. Could you help us understand that?
Yes, thank you. In LULAC versus Perry, the Supreme Court concluded that the Texas 2003 congressional redistricting plan diluted the vote of Latino voters, and in particular in one congressional district in Texas, which was a very geographically large congressional district, where the Latino population had been increasing. And Latinos had begun to flex their political muscle and vote for candidates who were challenging the sitting incumbent of that congressional district. At the time when the district was redistricted, it was about 55% Latino citizen voting age population. Texas dropped that number from 55% to 45% Latino citizen voting age population. And because voting in the district was extremely racially polarized, very, very high levels of polarization, the redistricting shifted the district from having the possibility of electing a Latino candidate of choice to really not having the possibility of electing the Latino candidate of choice. And what the Supreme Court recognized and noted in the opinion was that just as Latinos were coming to the point where they would be able to decide the outcome of the election in that district, Texas took the opportunity away. The court then explained that these actions bordered on intentional discrimination and were certainly dilutive. And we see that pattern over and over again, not limited to Latino voters, but voters of color across the board. In many jurisdictions where minority voters might have been a smaller portion of the jurisdiction and not exercising a lot of political strength, there is perhaps the willingness, for example, in Pasadena, to go to single-member district system to elect the city council. But then as the minority community grows and it becomes more able to elect members to council, and maybe even there's a moment where they might be able to elect a majority of the council, you often see a negative response, a response that either dilutes the vote or restricts the ability to access the ballot. That's what we saw in Pasadena. That's what we saw in LULAC versus Perry.
I'm interested in understanding, since Texas has been covered under the Voting Rights Act, the preclearance provision in 75, how many statewide redistricting maps have been challenged decade over decade as being discriminatory? Is this a one-off thing that is relegated in a particular period or something else?
It is not a one-off thing. Once the Supreme Court announced that states ought to be redistricting every 10 years under the one-person, one-vote rule, and Texas passed a redistricting plan in the early 1970s, each decennial period, one or both of the Texas statewide redistricting plans, either legislative or congressional, has been invalidated by either DOJ or the courts as discriminatory against Latino voters. So that would include the 1970 round of redistricting, the 1980 round, the 1990 round, the 2000 round, and then the 2010 round, which we're actually still litigating now. And we may not be able to get to a final remedy in this case before we are lapped by the next census. And that is directly a result of the loss of Section 5 preclearance in the Shelby decision.
So in light of that, there's certainly progress for Latino voters in Texas. Would you agree that the Voting Rights Act has made change and Latinos are represented in high political offices throughout the state?
Yes, we have made great progress.
So what does that tell us? On one hand, we have progress. On the other hand, what you've just told us is that decade after decade, there are statewide discriminatory measures directed at Latino populations. Are those two things something that one can hold in their mind at the same time?
Absolutely. While the Latino population in Texas grows, we used to have a poll tax in Texas, and this prevented many African Americans, Latinos, and others from registering to vote. We don't have that anymore, right? But as we have made progress, both in growing the size of our population and in increasing our political participation, Texas has been intransigent. And each decade with respect to redistricting has enacted plans that were subsequently found to be discriminatory, and under Section 5, not just discriminatory in a forward-looking way, but taking minority voters backwards, which is the retrogression standard. So we take some steps forward, and then we meet policies statewide and local that take us backwards, and we have to push and push again. And without Section 5, we have to do this primarily through very expensive litigation.
Ms. Landreth, recently I had an opportunity to travel to Alaska and learn a little bit about the voting circumstances on the ground in that state. There's a lot of talk about voting in the Deep South, some of the traditionally covered Section 5 jurisdictions. There's a lot of talk about Texas, but often what you hear as folks consider voting discrimination is that today's discrimination is not as insidious because it's not first generation, so-called first generation type discrimination. I think typically people think in terms of vote denial. You can't vote because you're a Native American, an African American, a Latino, but a second generation type of discrimination where votes are being weakened. In your experience as an expert litigator in Alaska and nationwide for Native American populations, what do you make of this distinction between so-called first generation and second generation discrimination? What kind of discrimination is okay for you?
I would say none of the above, Commissioner, but I suspect you already know that was the answer. I think that's one of the other talking points, so thank you for bringing this up. One of the other talking points I heard a lot in the buildup to Shelby and in the amicus briefs was that, quote, first generation barriers, the actual denial of access had been eradicated, and we were now really only looking at second generation barriers because we've made so much progress. That is absolutely not true. We know this not only through my work in Alaska. Frankly, if you're conducting an English-only election in an entirely non-English speaking Yupik population, you are denying access to the ballot box. But we also see physical denials, and one of the examples that I mentioned earlier was that there are indeed places where you are driving 40, 60, 90 miles one way, either to vote or to register. What is most common that we see is the refusal to locate polling places on reservations. And in one of the testimonies in one of the field hearings that we asked one of these people who had repeatedly asked, we said, well, what did they say to you? And the answer was this: the sheriff told us he would never allow a polling place on the reservation because it would be, and he made air quotes, a jurisdictional nightmare. What if the tribe just wants to keep the ballots? I'd have no authority to go get them. So there is different reasons provided, but the way that we most commonly see first generation barriers is the refusal to provide any physical access, and it has to be combined with some of the other factors. One of the reservations, they'd have to drive 40 miles in order to vote. And some people say, well, I drive 40 miles to work every day. Well, how about this? 45% of that population has no access to transportation. That is vote denial. That is the kind of thing we're finding all over the place. It's not just the mere failure to have a polling place. Even begrudgingly, when some of them are added, they'll make these very bizarre hours. We're open noon to 1 on Tuesday. And if you want additional hours, you're going to pay for it because we want you to pay for our staff. And so it changes. And it's like a game of whack-a-mole where you fix one and then they come up with another method. And it's just nonstop, one after the other. And so we see vote denial, but we see it in various forms. And we see first generation barriers in 31 different flavors across all the states.
Ms. Eiffel, sorry, one more? Okay. Time for one more. Ms. Eiffel, one of the things that I think we would use some help understanding is that the nature of an injury that flows from a voting discrimination. That is to say, what are the tangible impacts to people's rights? Are these things that can be limited? Do we just count cases and say, oh, there's only 1 or 2 statewide cases? Or is it more appropriate to think about the impact of these measures and, as you have spoken to, the duration of how long these measures are in place?
Thank you. Maybe I can combine this answer with a little bit of an answer to the question you just asked, Ms. Landreth, as well about kind of denial, because I regard these voter ID cases as vote denial cases. When you impose a voter ID law, as they did in Alabama, and then you close most of the motor vehicle bureaus where you would get that ID in the Black Belt, and you have the kinds of transportation issues that Ms. Landris talked about in Native American country, you are talking about vote denial. And so I do want to kind of make sure we're clear that we haven't cleared the first generation entirely yet. But your question is a really important one, because I sometimes worry that this conversation gets a little esoteric and we're not understanding what the relationship is between voting and citizenship, and voting and the ability of people to affect the material conditions in which they live, which is what the entire movement for voting rights was really supposed to be about during the civil rights movement. And it's one of the reasons why we spend a considerable amount of our resources focused on local elections, because too often when we focus on only elections that have national significance, for example, the special election last November in Alabama, everyone was focused on Alabama because it involved a state Senate seat and because there were potential partisan power issues in the balance. But you know, we're in Alabama every election day on the ground and dealing with the kinds of challenges that voters faced last November as well. And in those elections, they are voting for members of the school board, they're voting for district court judges, they're voting for district attorneys, they're voting for county council persons, they're voting for members of the county commission. And these are the individuals who control really the day-to-day lives of the people that we represent. In fact, they would tell you that those people control their lives more than their United States senator, more maybe than even the president of the United States. On a given day, what that district attorney does, what that district judge does, what that school board does, what that county commission does, affects the economic, educational implications of the lives of the people that we represent. And so when we take people, 600,000 people in Texas or 118,000 in Alabama, and we suggest that they no longer have the ability through these vote denial laws to participate equally in the political process and affect the people who are going to represent them and have that kind of control over their lives. We have removed them from democracy. We have removed them from having a say in their future. We've removed them from being part of the constitutional structure that says that they are full citizens. And so when we have these conversations, it's really important. And I just want to, make one more pitch on this attempt to try and make this about something partisan. Thurgood Marshall, who formed the NAACP Legal Defense Fund, founded it in 1940, one of his earliest successes was a case that he later described as his most important case. I'm sure we all think that that's probably Brown versus Board of Education, but what he said was that his most important case was a case he won in 1944 in the United States Supreme Court, Smith versus Allwright, challenging the all-white Democratic primary in the state of Texas, long before there was a Voting Rights Act or a preclearance provision. That's how long Texas has been in the game of voter suppression. So this has never been a partisan issue. This has always been about the ability of minority voters to participate equally in the political process. What we are saying to them when we allow these laws to go forward that keep them from participating in the kinds of elections that I described, we're saying to them that they are not full citizens of this country. We're saying to them that the 14th Amendment's promise of full citizenship cannot be realized. We're telling them that they are second-class citizens. We're telling them that they cannot be part of the democratic process of this country, and there's simply nothing we can do about it lest we hurt the feelings of the states. And that simply cannot be true. So we are at the point now where we're reaching farce around this question of whether Section 5 is necessary. The Shelby County decision was wrong. We knew it was wrong on the day, but if you thought maybe it wasn't wrong, what we have seen in the years since the Shelby County decision has borne out that it was in fact wrong. We've established that we can't keep up with the kinds of voting changes. We've established that the litigation takes too long. And we've finally established that hundreds of thousands, perhaps millions of people are being barred from participating in electing individuals who control their lives and who control their communities.
Vice Chair, I understand you have questions.
Yes, very quickly. We've been discussing in a large measure citizens that have the right to vote, but that right has been suppressed or frustrated, in some way made more difficult by the actions of their state legislators. But you, Ms. Eiffel, in your materials discussed felon disenfranchisement and restoration of the voting right to them. Why should this commission be concerned about that issue in the context of Section 5 and the Voting Rights Act?
Well, it seems to me this commission must be concerned about any law that prevents citizens, full citizens, from participating in the political process. And I think we've come to a moment in this country, at least thankfully, where there is a rigorous conversation about laws that deny those who have violated the law and then paid their debt to society to be held in a position of civil death, to be held as second-class citizens for their lives for a mistake that they made and that they paid for through their sentence and whatever else they had to do to fulfill the punishment that was meted out to them. And we also know that the origin of many of these laws, of these felon disenfranchisement laws, in many instances happened during a period, particularly at the turn of the 20th century, when Southern jurisdictions were rewriting their constitutions and were creating mechanisms to ensure that African Americans could not vote and participate in the political process. The origin of many of these felon disenfranchisement laws come from that period and were created in state constitutions in that period. And so we recognize that there are, and there always were, racial implications to felon disenfranchisement laws. But when we then combine that reality with the reality of mass incarceration that has resulted in the exponential growth of the prison population in this country since the 1970s. In the early 1970s, the prisons in this country contained 225,000 prisoners. That's the size now of the federal prison population. And now it's 2 million people who are imprisoned in this country. When we combine felon disenfranchisement with mass incarceration, this means that in communities all over this country, there will be citizens who have served their time, who have been in prison. And we are now suggesting that those citizens for life are to be held separate and apart from having a voice in their communities. And so, yes, this commission should be concerned about any effort that tries to remove or that in any way denigrates the full citizenship of individuals who are entitled to participate in the political process and elect candidates of their choice to control their lives, communities, and families.
Thank you. Commissioner Harriet?
Thank you, Madam Chairman. Mr. Adams, I was interested in the case that you were citing in Nevada about the recall elections. I assume that's a private lawsuit, though, right?
Indeed, I believe the lead plaintiff is named Luna.
But what about for another example of what you were talking about? Maybe you know something about the case about the city of Kinston here in North Carolina, where they had attempted to establish a nonpartisan ballot. Could you comment on that case?
Surely. This touches on my testimony that addressed the potential. It's now on. This case, Kinston, North Carolina, touches on the issue I testified about regarding abuse of the Section 5 process. And what happened in Kinston was that a law was passed, as I recall, that made elections in Kinston nonpartisan, right? They no longer were partisan races. And therefore, the candidates were not listed for city council, I believe was city council, as Democrat or Republican. They were just listed by their name. We hear the term a lot, I like to vote for the person, not for the party. Well, Kinston followed through and got rid of partisan elections. That was submitted to the Justice Department for Section 5 preclearance. And if this commission wants to see the depths of abuse that can be reached under Section 5, read the objection letter from Loretta King, who was the acting Assistant Attorney General at the time, where it talks about the fact that if you don't put the word Democrat on the ballot, that African Americans won't know for whom to vote. And it literally is the basis of the objection. And I think that was one of those unfortunate times where partisanship mixed up with enforcement of civil rights laws, because I think most Americans find that offensive. Some don't. Sure, people defend it, but most Americans find that offensive, that you have to tell people how to vote based on the party. And that's what happened in Kinston.
Commissioner Osaki? I do, but I'm fine. Go ahead. Okay. Mr. Marinoff, you included in your statement that you believe that there are other mechanisms different from preclearance and different from the enforcement as we had understood it before Shelby County that are more effective. And I would ask that you expand on that statement and also speak to it in light of the testimony that we've heard on this panel and the past panel.
I don't know that I did say that there are more effective alternatives. So I don't really know how to address that. There certainly are alternatives.
Your words were there are other forces that are more than sufficient to overcome discrimination that still exists.
Yes, okay. That was on a different topic, and it is not what I was saying. So let me
to have the
clarify. This was in the portion of my written testimony where I was discussing the impact of the Shelby County opinion on turnout through the laws that were put in place by jurisdictions, either put in place or actually enacted, whether they were enacted or just started to be enforced after the Shelby decision. I had been discussing the fact that there is a robust scholarly disagreement on what impact, if any, Shelby and the voter ID laws that have been discussed at length here this morning have had on voter turnout. I have pointed out in my written testimony and can flag for you now, there are scholarly articles that have determined that, in fact, Mr. Rosenberg referred to one of these in his testimony as well. The Hajnal article concluded that strict voter ID laws have a dramatic impact in reducing the turnout of minority voters. Minority here meaning African American and Hispanic voters. There are also scholarly articles that have concluded that there is a statistically significant increase in voter turnout that results from the imposition of strict voter ID laws. And the most recent that I've seen on this topic, the Grimmer article that I've cited to, concluded that there is no discernible impact across the nation from the imposition of strict voter ID laws. So on the one hand, we don't really know if turnout has actually been impacted at all by the entire slate of additional laws that we're talking about. What I had been saying, though, was that whatever the impact is, it does not appear that it winds up being election determinative. And there, what I was flagging was that if you just look at the high-profile elections over the last few months, both New Jersey and Virginia had gubernatorial elections in November. New Jersey, I believe, has no voter ID law or no picture voter ID law. Virginia has a comparatively strict law. Both elections saw record-breaking turnout. In New Jersey, it was record-breakingly low. In Virginia, it was record-breakingly high. So if we're trying to gauge to what extent is voter turnout a function of the presence of voter ID laws, this is going exactly the opposite direction. Similarly, the Alabama Senate race that was discussed a moment ago, the turnout in that election was highest in exactly the locales that had been identified as potentially impacted by what critics had said was voter suppression efforts. And that determined the result of the election. The high turnout in exactly those areas. So I was not saying that there are other enforcement options that are available and more effective than Section 5. I was simply saying that whatever impact Shelby has had, it does not appear to predominate over larger societal political influences on voter turnout.
Thank you. I see Ms. Eiffel, Ms. Landreth, you wanted to respond?
Because I really think it's important that we're very clear about this. So first of all, using high-profile national elections to determine whether turnout is affected or not, it seems to me it's just not a great scientific way to go about answering the question as to whether or not voter suppression laws have affected turnout. But more importantly, that's actually not the question, right? The ability of African Americans, for example, to be, as they have been, outraged by efforts to suppress the vote, whether it is voter ID laws, whether it is ending early voting and Sunday voting and undermining soul to the polls, and the willingness of African American voters to try and overcome that, to do as they did in 2016 and to stand in long lines, no matter how long it took to vote, to say, my vote will not be taken away from me. Those who were able to make it to the polls, those who were able to register, those who were able to get the ID, that they were able to overcome obstacles and determined that they would not be denied the right to vote. cannot be evidence that voter suppression laws have no effect. It's just simply not possible. And so I do think when we try to figure out what's the harm, and maybe this goes to Commissioner Adegbole's question earlier, the harm is not about a number on a sheet as to whether turnout went up or whether turnout went down. If a law is created particularly for the purpose, if a legislature meets and passes a law for the purpose of suppressing the votes of a particular group, or if a law is passed knowing that it's going to have the effect it's going to have, or as Ms. Landris described, simply not knowing because you haven't taken the time to figure out the fact that this polling place is not connected to another polling place by land, that's a problem of democratic governance. That's a structural problem that has to be dealt with and that was meant to be dealt with by the Voting Rights Act. And so it's not about whether or not it affected the outcome of an election in a given election. It's about the individual's right to participate equally in the political process and about freeing our system from something that has been the scourge of this country, that is our original sin, and it is the suppression of the citizenship of racial minorities. That's what the 14th Amendment was about. That's what the Voting Rights Act is about. And that's what the target is. The target is, can we free ourselves of these structural impediments, not what was the outcome of that election. And we should celebrate when communities refuse to allow themselves to become victims to these voter suppression schemes. But it doesn't make those voter suppression schemes legal. And it doesn't make them not a stain on our democracy.
Madam Chairman, may I add one thing?
Sure, but
please?
you're next in line after Ms. Lambert, sorry.
Oh, sure.
I just want to add two comments here that relate to both the impact of voter ID laws on voter turnout and also the partisanship issue. And if you'd like a perfect example of both, you can look at North Dakota. Senator Heidi Heitkamp was elected in large part due to the very large Native American turnout on reservations, and she put a lot of effort into that, and the turnout went up. Immediately after that, in one of history's amazing coincidences, the North Dakota legislature enacted what I will compete with Texas as the strictest voter ID law in the nation, for the reason that it didn't even have a fail-safe. If the person knew you, could identify you, and you had every piece of paperwork in the world with your name on it, you could only have a certain limited subset of IDs that you had to get from the state. That, of course, required an original birth certificate, so the costs went up and up and up as you went through this process to try and get all of this. A lot of Native Americans were born at home, the elderly ones in particular, and could not produce some of this paperwork. And we saw the turnout in these precincts go down, because that was the purpose, was to punish them for electing a Democrat for North Dakota and to make sure they couldn't vote. And let me explain exactly how it was targeted to Native Americans. It required that they have street addresses on their IDs when their reservations are the only places that didn't have street addresses. Now, they went ahead and platted them, but the people don't know what their addresses are because they refer to themselves as, oh, I'm on the rural route on the left, or I live behind the store. So the state claims, well, we gave them addresses for purposes of fire and emergency, but they have no idea what those are. So that's a perfect example of how partisanship has been used in the other direction to disenfranchise a particular community that became powerful through its exercise of the franchise. And the way they did it was through a voter ID law targeted to that community.
Thank you. Mr. Rosenberg?
Yes, thank you. Very briefly, I want to reiterate that I agree with Ms. Eiffel that using voter turnout is a very, very weak metric, and particularly where we know what we know. And what we know that was that in Texas, for example, 600,000 Texans, predominantly Black and Hispanic voters, did not have the required ID. It was 2 to 3 times more difficult for them to get the ID. It was 2 to 3 times more difficult. There was 2 to 3 times more of a burden on them to obtain the ID when they didn't have it. At the same time, this was a law that was justified supposedly to stop in-person voter fraud when there were 2 cases out of 20 million votes cast in the 10 years leading up to the promulgation of the Texas photo ID law of in-person voter fraud. So the equation is between a law supposedly meant to stop a non-existent problem on the one hand, when you know that there are hundreds of thousands of people who don't have the ID. We should be doing everything we can to facilitate the right to vote, not to stop people from voting.
Thank you. Commissioner Yaki, you want to have the last question with our remaining 3 minutes?
Yeah. This is actually more of a homework assignment for some of you. I think what's very important is, for the purposes of reinstating for however way we can the pre-Shelby standards, we're going to need some very good documentation, and you have a lot of it in your testimony, and I don't want to ask you to elaborate on it anymore, but what Bishop Barber said earlier about the wholesale, it's not just one little thing, it's a wholesale attack on voting rights that has been going on since Shelby, not just on voter ID. It's about polling places. It's about driver's license hours. It's about purges and challenge proceedings in states. And given the fact that we can supplement the record, I would really ask you to give us more of that information, because as much as someone would like to try and say this is a Democrat or Republican issue, it is not. It is, as Commissioner Adegbile said, this is about how we work as a democracy and how those people who vote are there and basically the consumers of the ideas that political parties and men and women of good intent try and persuade you to vote. But they're not going to be able to do that unless they can vote in the first place.
Commissioner
And that's going to be really
I told you that the
important.
last question, but I understand Commissioner Narasaki has a question. I think you've asked yours.
Okay.
Thank you.
Like Commissioner Yaki, I have additional homework. So two things. One is I know that some of your organizations run hotlines during the elections, and I think it would be helpful for the commission to have the benefit of those reports about what is actually happening in terms of stopping the problems that people are having at the polling places. And the second one is I had asked earlier for your recommendations about what we should be advising Congress about what the Voting Rights Act should look like, should they get to it. And it would be very helpful for you to submit, while our record is open, your thoughts on that. Thank you.
Thank you all. We are right on time closing. This is a very powerful panel. As again, I very much appreciate your testimony, your giving us your expertise. And I remind the audience, we will come back at 1:20, and there are spots remaining in the public comment period if people would like to sign up in the room next door. Thank you.